Okay, good evening. This
They,
is a regular meeting of the Princeton Zoning Board of Adjustment being held electronically via Zoom on July 22nd, 2026 at 7:30 p.m. Adequate notice of the time and place of this meeting has been given by prominently posting notice of this meeting on the official bulletin board at the Princeton Municipal Complex, by filing a copy with the clerk of Princeton on July 8th, 2026, and by posting a copy on the municipal website homepage, www.princetonnj.gov/1527/public notices. Okay. Taylor, can you call the roll, please?
Absolutely. Miss Chen, Miss Colson,
Here.
Mr. Floyd,
here.
Mr. Schreiber,
Here.
Mr. Tenenbaum, Mr. Stein,
Here.
Miss Donna, Mr. Dobkin,
Here.
Chairman Cohen.
Here. Okay, we have two resolutions this evening. The first one is case number Z26-734, 222 Moore Street, block 7110, lot 22 in the R8 zone in the township. The resolutions should have been in your packet online. If anyone has any question or comments, or if not, if someone would like to make a motion.
Steve, I do have one substantive revision, having conferred now with the applicant's counsel and with our zoning officer. Paragraph 6 and 7, there are references to the distance that the garage is going to be moved closer to the house, and everybody's in agreement that what it should be is 3 feet 10 inches. So that's the change I would propose. The variance that they need for the side yard is still 5 feet, but everyone seems to be in agreement that the distance that it's being moved to be closer to the house is 3 feet 10 inches.
Okay. Okay, board members, any question on that? Okay, someone would like to make a motion? Anyone?
I'll move approval. This is ridiculous.
Second.
Thank you, Michael. Okay. Taylor, can you call the roll, please?
Miss Colson,
Eve, you're muted.
I see that. Yes. Sorry.
Mr. Floyd,
Yes.
Mr. Schreiber,
Yes.
Mr. Stein,
Yes.
Chairman Cohen.
Yes. Thank you. Okay, our next resolution is case number Z25-676, 105 Mountain Avenue, block 6804, lot 19 and 20 in the RT Township Zone. Again, the resolutions were in your packet, and if there are any questions or comments, if not, if someone would like to make a motion.
I move that we accept this motion.
Thank you.
Second.
Thank you. Okay, any question on this? Okay, Taylor, can you please call the roll?
Miss Colson,
Yes.
Mr. Floyd,
Yes.
Mr. Schreiber,
Yes.
Mr. Stein,
Yes.
Chairman Cohen.
Yes. Okay, we have 3 hearings this evening. The first one is case number Z25-654, 25 Henderson, block 6804, lot 11 in the RT Township Zone. This is a continuation, I believe. And I have a question of our counsel. Karen,
Yes.
in light of everything that was in the packet
Yep.
and, some comments from the court and things like that.
Mhm.
Is there anything that can happen now that would cause us to change what we may do this evening?
I don't think so. Right now, and actually while I'm talking, Taylor, I think the applicant's attorney still has to be brought over. Because I see a lot of people oh, there he is. Okay, great. I mean, at this juncture, the court has made rulings, but has also referred the parties back to mediation to still look at any outstanding issues. In terms of what it would change for the board, this issue will come up later during the hearing, but I mean, this is within the court's jurisdiction now. And the courts determined that the applicants do own the portion of Henderson Road that was, I guess, being disputed by their neighbors. So courts made a ruling. They found that some of the neighbors have what's called an easement by necessity because they have no other way to get from their property to a public street. Some of the other owners, the court found they have another means of access and that their claims were dismissed by the court, but without prejudice, meaning they could refile them if they have additional information for the court to consider. So I don't see from the perspective of now the variances that are in front of the board for the applicant's property, I don't know why that would be affected by the court's ruling.
Okay, that's fine. All right, so let's continue on this. I guess whomever's in the audience that needs to be let in, please do that, and let's begin. Taylor, do you want to review your memo with us?
Yeah, I just wanted to make sure that everybody was over from the attendees side.
Mr. Tadaro, who else do you
Yes.
need?
So we are looking our, let's see, our planner, Susan, Benjamin Grace. Susan has her hand up. She just had her hand up. From BFJ Planning. Joshua Zinder. And should also have Wayne Ingram, our engineer and surveyor.
Taylor, if you can summarize your memo and then we'll begin.
Let me
Well,
just
first of
swear
all,
you in,
excuse me.
Taylor, for the evening, and I might as well, where's Jim?
That
I'll
was
swear
everybody,
Jim.
right?
That's everybody
Is that-
from
okay.
All right, I will,
One
I
question,
will-
Karen, we can hear this, everything's in order?
it is, and it's been carried several times now.
Yeah.
Let me just swear in Taylor, Jim. Do we have our planner here? Taylor?
We do not. Nope.
We do not. Okay, then it's just you and Jim. Do you swear affirm your testimony this evening will be truthful?
I do.
Thank you.
So tonight you'll hear testimony regarding 25 Henderson Avenue. That's block 6804, lot 11 in the R2T zone. The owners and applicants are Boris and Helena Hayda. The applicants are proposing to demolish the existing single-family home on the lot to construct a new two-story single-family dwelling. The subject property, again, is located in the R2T zone and is subject to the use and bulk regulations in accordance with sections T10B 246, 255, and 255.2 of the former Princeton Township Land Use Ordinance. The subject property is not located within a locally designated historic district and therefore did not need review. The application, or the applicants are proposing to demolish an existing 1.5-story single-family dwelling to construct a 2-story single-family dwelling. The subject property is a flag lot. There is a question regarding the ownership, as we have heard before tonight, of ownership of Henderson Lane from the subject lot to Mountain Avenue. The subject lot does not have direct frontage on the public road of Mountain Avenue, and therefore a variance from NJSA 455:D-36 would be required if the applicants are not able to gain access to Mountain Avenue. Note that if the board is inclined to act favorably on this application, a condition shall be placed that the applicant shall present proof of record of ownership for Henderson Avenue prior to the issuance of a zoning permit. The following variances are required. A variance from section T10B 255.2, section E1A for the location of the side entry garage, where the requirement is the garage must be recessed 8 feet from the front facade. The proposed is located in front of the proposed principal structure. A variance from code section T10B 255.2 E2A for the width of the side entry garage, where 50% of the principal dwelling or 30 feet is required. The garage width is 26.7 feet, where the overall width of the structure is 37.82 feet. A variance from code section T10B 255.2 C2A for exceeding the permitted length of a side-facing wall, where the requirement is 40 feet. The proposed is 42.69 feet. And if the board has any questions or concerns, I'd be happy to answer. Otherwise,
Board members, any questions? No, please continue.
Fantastic.
Okay, so I guess at this point, Mr. Tadero, do you want to begin?
Yes, thank you, Mr. Chair, members of the board, Anthony Todaro of the law firm of Fakery, Drinker, Biddle and Reith on behalf of the applicants. And as zoning officer Griffin just mentioned, this is a very straightforward residential project where the applicants are proposing to replace the existing older home, which has several nonconformities and encroaches into the setbacks of our neighbor with their forever home. And so the reason that we're here tonight is because we have certain technical variances and some minor deviations due to the property's lot configuration. And so what I mean by that is the property is a flag lot. So the flag portion's the yard area where the home's going to be located. And the pole is a private driveway leading to the public street of Mountain Avenue. And so because of this configuration and due to it being a side lot, or excuse me, a flag lot, unlike our neighbors, we need to treat what would otherwise be the side yard as our front yard and vice versa. So that triggers the variances that the zoning officer was just mentioning and including in our memo, such as the garage and lot width. It's quite a large piece of property. And so another issue that the applicants had to contend with had to do with a title issue, actually. So around the time that the applicants acquired the property, they discovered that a portion of Henderson Avenue is not part of their deed, not part of anybody's deed. And so the way to resolve that is you have to file with the court and get a determination as to ownership. Took a while, and but we're just recently able to get the judge to render a decision deciding the issue of ownership in favor of the applicants. So now we have a court order from the judge explaining that all of Henderson Avenue is in fact part of the subject property. And so what remains in that litigation is all of the easement rights, apart from the easements by necessity that some of the neighbors were recognized for some of the neighbors in connection with the judge's decision. And so because of that decision, what we've done is we've actually modified our plans, because we had on our survey that part of the Henderson Avenue ownership still in dispute. So the lot size was slightly larger than 1.5 acres. Well, now that we're able to include all of Henderson Avenue, it's slightly larger. It increases the impervious cover, but we are still within the impervious limitation. There's no impact to the FAR calculation. And so we want to actually show it in connection with the entirety of Henderson Avenue. It actually also alleviates 2 of the other variances that we had originally requested, because the lot technically didn't have frontage along Mountain Avenue, which is a public road. So here tonight are the applicants to give a little bit of additional context, let the board know how excited they are to actually move forward on this stage of the process, become residents of Princeton. We also have our architect to run through the renderings and the plans, as well as our surveyor engineer, and then we'll conclude with our planning testimony. So I'll leave it to the board's attorney as to whether we want to swear everyone in all at once.
I guess we can do that. All right, so we have Mr. and Mrs. Hayda. We have Susan Favati, the planner. We have Mr. Zinder, but I don't see you. So if you could,
Yeah, I think we're going to have Ben.
thank you.
I'm actually not
And-
providing testimony tonight. It's going to be Ben Grace from my office.
Okay, all right, Mr. Grace. We have Mr. Ingram. Did I leave anybody out?
All good.
All good? Do you all swear or affirm that your testimony this evening will be truthful?
I do.
I do.
Thank you.
I'll start tonight with Ms. Hayda. So I just ask that you introduce yourself to the board. Oh, they can see. Hi, can we hear you?
No, we can't hear you, ma'am.
Right off the bat.
Well, do you want to come back to them?
Yeah.
Or,
Yes, let's do
Yeah.
that. So why don't we'll hold off while they rearrange the speakers. We'll shift over to Mr. Grace to run through our architecturals.
Mr. Dodaro, do you want to qualify Mr. Grace?
Yes, I just want to make sure he wasn't muted first.
Okay.
Mr. Grace, can you just give the board the benefit of some of your credentials?
Sure. I'm a registered architect in the state of New Jersey since 2016. My license is in good standing. I have a Master's of Architecture degree from Syracuse University. I have presented in front of this board and other boards in Princeton and in Mercer County and other localities of this.
We'll accept you as an expert.
And did you prepare or cause to be prepared plans in connection with this application?
Yes, I did.
Mr. Grace, do you think you could increase the volume on your sound?
I see. Is that any better?
Oh, that's much better. Thank you.
Okay. All right. I'm going to, we have a presentation of 23 pages that we'd like to share during our testimony.
So you mean it'd be a 23-slide PowerPoint?
Correct. Yes. This was
Okay,
submitted
great.
previously to the zoning office as well.
And Mr. Tadaro, so we want this to be Exhibit A1 collectively?
Perfect.
Okay.
Okay, is my screen visible?
Yes, it is.
All right. Well, thank you for having us here tonight. I'm going to briefly show you a couple maps just to provide some context. Here you see an aerial photograph on page 1 of the site, Mountain Avenue running diagonally across the bottom of the page. So the subject lot is highlighted with an orange outline here. Henderson Avenue is the whole portion of the flag lot. And then flag portion of the lot extends all the way back up to the Mountain Lakes Preserve. And this is same view just as a Google Maps image. Here on page 3, you see some existing photographs of the house currently on the site, which is proposed to be demolished. The 1.5-story house with a 2-car garage and a partial basement. It's a rather small footprint. The house is not in great condition itself. The garage as well is rather small, not really functional for present day automobiles. Here you see an existing site plan. It has been rotated to better fit on the page. So you'll see the north arrow pointing to the upper left corner of the screen. Mountain Avenue is on the right-hand side of the page, and Henderson Avenue runs across from the right side. And this orientation is how we will be presenting the rest of the plans in this presentation. The orange outline that you can see here describes the boundary of Lot 11, the subject property for this application. And again, it incorporates from the recent court judgment the full length of Henderson Avenue as part of Lot 11. I think it's important to note that this property does not front on Henderson Avenue. Henderson Ave is part of the property. The property frontage is along Mountain Ave, the short length at the right hand of the screen here. The pink line you see represents the 30-foot setback, setback line, which is applicable on all sides for flag lots. And here in gray, solid gray, you can see the footprint of the existing house with the garage at the foremost portion of the flag portion of the lot, right up against lot, and the neighbor is lot 16 there. The garage does not conform to the current setback requirement along this boundary, which would be the pink line here. A few other features of the site to make note of here. It's not very well visible on the screen, but there's a jagged line running from the top across to the bottom left about midway through the site. That describes the edge of the existing wooded area on the site. There's also a stream on the site, and we have a kind of an arc here which describes the 300-foot riparian buffer from that stream. And we also, you might be able to see them on here, they're faint. There's a significant grade moving towards the back of the site. It slopes significantly down towards the creek. So these features all in combination describe what is the buildable area of the lot, which I'm kind of circling with my pointer at the moment. I'm gonna go flash ahead. This page 5 has the proposed architectural site plan. On this site, you'll see the proposed footprint of the proposed structure in yellow. There will also be, there's a privacy fence proposed at this east corner of the lot, extending both towards Mountain Avenue and towards the neighboring property to the east, lot 1201, from the garage. You'll see here also in green the trees that are being proposed to be added to the lot as part of the replanting required for some of the trees that will be removed. This is described on the mission document. You'll see here that the proposed house this footprint complies with the setbacks on all sides. The proposal also complies with the bulk requirements for FAR, height, and height to setback ratio. Here on page 6, you see the proposed first floor plan of the building. At the heart of the building is really a 4-square here with the main living spaces, a combined living and dining room at the north, and a kitchen and den at the bottom, with a hallway running across in between the two spaces. You'll see there's a primary bedroom suite at the left of this plan to the back of the site with an ensuite closets and bathroom. These spaces are designed to be on the same floor as the primary living spaces to allow for the client's seamless mobility and allow for them to age in place as the time passes in this house. There's also an elevated deck at the same level as the finished floor off the back. And this leads down to an at-grade patio at the rearmost part of the building. To the right of the primary living spaces in the main building is their entry foyer here, and here's the main entry at the bottom right. A small hallway of secondary support spaces, including a pantry, an office, a mudroom, restroom, mechanical room, leads to the garage at the right-hand side of the page here. There is a second floor on page 7. The second floor consists of 3 bedrooms and 2 bathrooms. It's only over the center portion of the structure. All the other areas you see that are not filled in with color on this page are single-story structures: the garage, the suite at the back of the building, and the kitchen and den space below here. Here, I'll introduce you to the primary building materials for the exterior of the building. At the center, you see Shosugiban siding, which is a charred wood siding, proposed as the primary exterior building material, which will be accented with a wood look siding, as well as a cultured stone veneer. And here you see a 3D view of the exterior. This view would be from the front of the property where the Henderson Avenue pole meets the flag portion of the lot, kind of right in front of the neighboring lot 16. I'll highlight the entry location here. The garage to the right. There's a privacy fence here. You can see the single-story volume for the garage, for the entry portion of the building here. The stair is contained in this stone-clad 2-story element. There's a light shelf here. Note for visualization purposes, this is provided to give you an understanding of the building volume. It doesn't necessarily accurately reflect the full extent of landscaping or hardscaping. So I also included this slide just to describe the existing Henderson Avenue streetscape. Starting from Mountain Avenue, for the first 2 houses you see here on lots 13 and lot 20 address Mountain Avenue as their front. So the elevations along Henderson Avenue are side elevations of those houses. Here moving to the left, you have lots 14, lot 15, lot 16 on the top of the page, and lot 18 at the bottom of the page. These houses address Henderson Ave as their front. And here you can see the existing footprint of the structure on lot 11, subject lot, in yellow. I'll also note we have just included the approximate footprint of the addition to 105 Mountain Avenue on lots 19 and 20, which was approved at the June 24th hearing.
And that was for the resolution that was adopted tonight, correct, Beth?
Was that question for me, Anthony?
Yeah, I was just saying, and I believe that was the same, just to help the board, that was the same resolution that was on for tonight that was adopted.
Yes. I've included this slide just to describe the setback regulations a little bit more. So for the flag lot, the setbacks are more restrictive than the standard R2 district setbacks. And I'll just say on this slide, we have overlaid the existing building footprint, which is here with the angled hatch, and the proposed building footprint, which is in gray, the solid hatch. So the flag lot requires a 30-foot setback on all sides, whereas the R2 regulations require 20 at the side and rear and 25 at the front. What this means, especially with a lot that is narrower than that anticipated by the zoning, 107 feet is the lot width at the building portion of the site. It's a further limitation on the dimension of the building and the buildable area for the building. The proposed design will bring the lot into compliance with the setback requirements, whereas the existing building, as you can see, does not comply with the 30-foot setback requirement against lot 16. The entirety of the existing garage is in that setback area. Also on this slide, we have the zoning regulation summary table. This is also found on the variance plan drawing sheet produced by the civil engineers, French and Perello. This table does slightly vary from that which was submitted, as it now reflects the judgment that the entirety of Henderson Ave is part of the lot. There will be another slide at the end of this presentation which describes more clearly the changes to that table. Addressing lot width. The lot width is an existing nonconformity for the site. The required lot width in the R2T district is 175 feet minimum. So the lot width at lot 11 is 107 feet. This is at the flag portion of the lot, not the pole portion. The pole portion of the lot meets the minimum width requirement for a flag lot pole. So this slide is taken from the town's tax map. The slide shows you the entirety of block 6804. There are currently 26 lots on the block, of which only 3 comply with the required 175-foot width. The other 23 do not. The purpose of this is simply to show you the prevalence of the width nonconformity in this block. The other items from which relief are sought are from the neighborhood residential zoning standards section of the ordinances, and we'll go through those briefly next. This is an excerpt from the ordinance T10B 255.2E regarding side and rear entry garages. This is page 13. And it contains figures 13 and 14 illustrating these requirements. So our lot is not, our proposed structure and the configuration of the lot don't lend to a precise correlation of this diagram to the proposed structure, simply due to the fact that it's a flag lot and that the building is not really fronting directly upon the public streetscape. But when we originally met with the former zoning officer, Derek Bridger, and the former land use engineer, Dan Weissman, to discuss this application. Both of them agreed that this would be considered a side-facing garage and identified that the applicants would need to seek relief both for the location and the width of the garage. Both of those requirements are located here, are on this sheet. For location, the garage is required to be recessed behind the facade by 8 feet minimum. And for width, the width shall be no wider than 50% of the overall width of the structure or 30 feet, whichever is less. So here I try to make a bit clearer the differences between the diagram then contained in the ordinance and a diagram, and a similar style diagram of our building. Our condition varies from this generic diagramming that we are a flag lot. The frontage along Mountain Avenue is over 300 feet from this building. My understanding is that part of the intent of the ordinance is to prevent large blank garage sidewalls from becoming a dominant element along the public streetscape, both by their location and width. The condition on lot 11, since it is a flag lot, is different. The side of the garage faces not a public street, but the side lot line of a neighboring property. So here we see a focus view on the existing condition. The garage is at the foremost portion of the flag piece of the lot, and it is just under 7 feet from the shared lot line with lot 16. It does not comply with the 30-foot setback along that boundary line, and almost the entirety of the footprint of the garage is in the set backyard area. I'll highlight 2 other items on this slide. The dimension between the side setback, the buildable areas, is both side setbacks rather, which defines the buildable area, is approximately 47 feet. This lends itself to an organization on structure which runs lengthwise across this page rather than across the lot, up and down on this page. And the dashed line again on this slide describes the footprint of the proposed building. And you also note there's an approximately 11-foot dimension here between what is really the front wall of the existing building and the garage door, the wall with the garage doors. This slide shows the proposed condition. The garage again is highlighted in orange, same as the last slide. The yellow area describes the interior living areas, and the lighter yellow color describes the porches and decks, with the gray as the hardscape area of the driveways, patios, walkways, etc. You see the existing footprint relative to the proposed. The proposed garage is more than 35 feet further from the boundary line at lot 16 and complies with the setback requirement. Similar to the existing condition, the garage is in front of the primary building wall, which faces the street, Mountain Avenue. And the relationship of the west wall, this is the bottom wall on this page, of the building to the garage door wall is approximately 11 feet, consistent with the existing condition. These show the same diagrams, but highlighting the width. For the existing condition, the garage width is 20'4", a dimension which may just about fit a car, but without the room to open doors or circulate around a vehicle comfortably. Not practical for modern use. The overall width of the existing structure is 31 feet, 7 inches. So the relationship of the width of the garage to the width of the building, it is more than 55% of the width of the overall building and does not comply with the intent of the current standard. The proposed garage is 27 feet wide, deeper to better accommodate vehicles and circulation around them. The ratio of the relationship to the proposed building width, which is 38'4", is very similar to the existing ratio with a modest increase to both the width of both elements. While the garage does not comply with this standard, we feel it is more appropriate applied to structures directly facing streets. We feel it does, but we do feel the approach to the garage approaches the site sensitively. It positions the garage 35 feet further away from the most immediate neighbor. It maintains the garage at the foremost portion of the buildable lot area, which limits the amount of hardscape devoted to vehicular circulation on the lot. And the garage is a single-story volume with no occupiable space above. Regarding the relief request for the facade, the sidewall facade length, I've included excerpts from the ordinance here. So at the top, section B addresses articulation of walls facing a street. Here you'll see 45 feet is the maximum length. Of course, any steps are required. And the bottom is section C addresses articulation of walls not facing a street. And 40 feet is the maximum width permitted before walls are required to be stepped for a side or rear facing wall. So this slide shows the neighborhood plan and highlights the wall length here, which is subject to the relief request. The southwest facing wall is 42 feet, 42.67 feet. The wall is part of the kitchen, den, and entry foyer for the building. You'll see we've highlighted the houses on the roadway which address Henderson Avenue as their front in this light orange color, whereas houses that address Mountain Avenue as their front are called out here. They're gray in color. These houses that you see in yellow would technically be permitted to have 45 feet wall length as their front without any stepping required. And that you'll see the house on lot 18 does have a wall length of approximately 45 feet without any break in there or stepping in the facade. The applicants are seeking relief to allow for a small increase in unbroken wall length for this portion of the building. It's a single-story wall with fenestration, continuous clear story, an intermediate canopy, as well as a raised planter bed at its base. It is not a large blank wall. It is a carefully considered wall with fenestration and natural breaks of the design. And that's page 22. That concludes the presentation I intended to give here. Wayne, I'm going to hand this over to you.
Fantastic. And so while Mr. Grace isn't going anywhere, we'll just turn it over to Mr. Ingram unless the board has any questions at this time.
Board members, any questions? Okay, please continue.
All right. Mr. Ingram, I believe we could see you.
Anthony, could I interject? Are you able to bring Boris and Helena back so that they can make their introduction? Should we do that now?
Yes. So there's a phone number. It ends in 7399. They were having technical difficulties, so we were able to get them to call on.
Okay, can we see them though? Maybe you could stop sharing for the moment so we can see them. Or
They can call in, but if we just can
well, I know
see-
that, but at least we were able to see them previously. So if they can turn their video on.
I just
Yeah,
tried
we
to
do.
allow them to speak. I don't know if
Yeah.
you'll see a video though, Karen.
Oh, it says they're joining.
They're still logged in on their computer as well as the phone.
Hmm.
So it would be helpful if we could at least see them. I appreciate that they need to participate via phone, but
They can turn their video on.
yeah, that would be fine.
It says their audio is muted on the phone call.
Okay, where'd they go now? Now they're gone. Okay.
Okay, so I think while they're sorting that out, I think we should just pull up the variance plan, just keep going, and we could bring them back in once they resolve those technical difficulties.
So if I understand, Mr. Ingram's going to testify. Could you qualify him, please?
Yes, please. Mr. Ingram, are you here?
I am, yes.
All right, great. Can you give the board the benefit of your credentials?
Sure. A degree in civil engineering from Rutgers University.
Can you hear us now?
Yep. Sorry about that.
Can you hear us now?
All the irons out.
Yes.
We can't hear them now.
No. Oh, because the speaker's off.
We can hear you and see you.
Yes.
Okay. Now it's off.
No, we
Can you hear us now?
We can still hear you. Yes. Can you hear
I was
us?
like, we can't hear them.
Obviously, we're not in our 20s anymore. Sorry. So sorry for the technical difficulties. Thank you so much to the board, to our team, to our future neighbors for joining the call tonight. My name is Helena. This is Boris, my husband. We have been living in our home in Upper New Jersey, Northern New Jersey, for over 35 years because we've both worked in Manhattan. And when we got the great news that our daughter was expecting our first grandchild, we decided we needed to move closer so that we could be with family. and have an impact on all of us. So when we found this property, we fell in love, and it is such a wonderful location. Our daughter is a high school teacher at Princeton High School, teaching biology and environmental sciences. And what we plan on doing is providing childcare for her. She can drop her child, soon to be a second one, off at our house, and we will be watching her children and enjoying grandparents and grandchild time. And this is our dream home forever. Obviously, we don't move around a lot since we've been in our current home for over 35 years. And this is the only thing that would have gotten us to move away from our current home. And we're very much looking forward to building our dream home and staying there for the rest of our lives with close proximity to our family. Thank you so much for listening.
Board, yeah, we want to thank you for your listening to this, and you for your consideration, and looking forward to a successful project. Thank you. And I guess I'm finished, I guess, or
We're at sequence. We apologize.
yeah. Sorry about our technical.
That's what we had to say.
They're not going anywhere. We'll work that out so they can hear you. But in the meantime, I think we'll turn it back over to Mr. Ingram to discuss the variance plans.
Sure.
I think
So
we were
get back to Paul.
interrupted in qualifying him, so maybe he can begin again.
Yes, why don't we just start over and giving the board the benefit of your credentials?
Sure. Degree in civil engineering from Rutgers University and NJIT in land surveying. I have been practicing engineering for over 20 years. And I've also been a licensed surveyor for probably 14 years now. I've been qualified in those capacities, probably in front of at least 75 boards throughout the state, including previously in front of Princeton.
And both
We will accept you as an expert.
Thank you.
You're welcome.
Wait, and both licenses are in good standing?
Yes, all my licenses are current and valid.
Awesome. And while it's already been marked as an exhibit, can you just let the board know what we are showing to them now as the variance plan? Is this a plan that you prepared?
Correct. So this is just an updated sheet one of the variance plan as previously provided, with the adjustments simply being inclusion of Henderson Avenue within the bounds of the lot, and then the updating of the zoning table to account for the effects that has. So I guess you've already gotten a pretty good description of the property and the lot, so I won't be repetitive in that. We prepared the site plan for the application. The property itself tends to slope from the higher side on the southern end where the existing home is to the north in the rear. As was mentioned, the lot does have a lot of steeper slopes and wooded areas to the north. There's a small stream in the back. We've conservatively set the stream buffer and on the plan such that we are well outside of any possible environmental sensitive areas with our proposed work. What the application proposes is to remove the existing structure that was well described to you as being fairly close to the southerly property line. We're going to basically shift that to put it within the required setback lines with the new home. We have existing utilities which come down Henderson Avenue, which service the current home as well as some of the other homes on the street. Those will remain unaffected. The main lines will still remain. We will just retap the lines that currently went into the property for sewer and water. We will be dropping an underground electric service from the pole, whereas is currently overhead. And basically extending the driveway a little further down Henderson to serve as the driveway portion once it gets past all the other homes that use it for access. And at that point, the darker shaded gray area is what is used solely by the applicants. We have noted some minimal tree removal. I think we have 4 trees which are below the municipal standard as requiring replacement. 5 others that would require replacement, which we have provided on site and also calculated and agreed to the fee compensation. We are proposing a stormwater management rain garden, which would be located on the northern end of the property. And that would be picking up all the roof water from the proposed home. We have performed soil testing, provided the calculations. We've provided a draft maintenance plan for that to mitigate any stormwater impacts of the project. Really, other than that, it's a pretty straightforward layout for the project. We're working in the area that is essentially outside the wooded area and somewhat level, so there's only fairly minimal grading required for the site. We did update the zoning calculations. I think they've been previously discussed. We are basically, with the addition of the flagpole portion of the lot, we are sitting at 18% coverage. It's basically, the increase is just under 6%, which was what was originally presented to the board. The only change, again, being factoring in the additional area of the flagpole into both the lot size, but as well as impervious. And it is rather heavy on impervious in that area because of that shared driveway. We have a fire hydrant, which is located on Mountain Avenue, about 120 feet or so from the driveway for Henderson Avenue. So it's on the main road, about 120 feet away, and then it would be 286 feet to the main body of the lot, and we're another 40 feet behind that. So we're looking at about 440 feet to that hydrant. Not substantially different than the condition which currently exists. We have had the lot looked at by the fire department. We're not aware of any concerns that were raised with that.
And so I believe, if my math is correct, it's less than 20 feet difference, and that's to accommodate the new structure being within the setback, correct?
Yeah, the garage is 42 feet off the front line, whereas the current one is about, I think, 6. So that puts us about 36 feet further away.
Okay. And I just have 2 quick clarifications for you, Mr. Ingram, on this. So we're also proposing, I know Mr. Grace previously mentioned that we're replacing the existing fence with a new privacy fence. And we show it on here. We have a proposed 6-foot board fence.
Yes.
In that portion of the property.
Correct.
Okay. And the other item that you mentioned with dropping the electric line that services the existing home, that's just a line from a pole that services only the existing home, correct?
Yes, so there's a pole that is basically right where the flag pole meets the main body of the lot, and there's overheads now, and we'll be dropping that down to underground as required by the ordinance.
Okay. And we'll work that out with the utility company, correct?
Correct. Yep. So no modifications proposed to the shared portion of the driveway. Everybody who has access will maintain access. Who's legally required to have it. No effects to any of the existing utilities. We're basically able to primarily work within the body of the lot, not the flagpole.
Great. And you also prepared the survey in connection with this variance plan. Is that correct?
We did, yes.
All right. And in your opinion, the judge's ruling just allows you to draw the subject property's lot boundaries all the way down to Mountain Avenue?
That's correct.
Okay. And that's because when you looked at the documents and title, you couldn't do so? The portion was missing?
Yeah, so in the original title documents, there was a kind of a strange jogging of the front line and the flagpole right within towards the end of the flagpole. As we basically went through as much deed and title information as we could possibly find, back to the creation of these lots, it appeared that Henderson Avenue was never deeded out beyond this lot. And for that reason, the court determined that it was remained as part of our property.
And then if we could just flip to the next slide, I just want to bring that point home because we just updated the zoning table to reflect that additional lot size.
Correct. So we adjusted both the existing and proposed conditions, and we would obviously provide the updated plans to the board reflecting those changes. But the lot size changes is increased in both existing and proposed. We now have the lot frontage, which is unchanged. And then we have adjusted the impervious coverage. Again, I think the delta between existing and proposed is consistent. It's really just the change in the that's created by the flagpole.
Absent any questions for Mr. Ingram, I'll jump now to our professional planner to provide some.
Mr. Tadaro, I do have a quick question.
Sure.
For Mr. Ingram. I didn't catch that quite clearly when you were testifying about the distance between the dwelling and the hydrant. We do have a requirement in our flag lot requirements that the distance between any dwelling and a hydrant shall not exceed 400 feet. You could just advise.
Yeah, I think the issue is if it's as the crow flies, I believe it'd be within distance. But because basically it's on the main road and you'd have to come down the driveway, it's located easterly of the property to the flagpole about 120 feet. You have 286 feet down the flagpole, and then we are 42 feet behind that. So we were calculating roughly 440 feet. It's also deficient in the current condition from that standard as well.
Okay.
So then wait, then a variance would be needed for that, Taylor?
Yeah. Yeah, because the requirement says shall not exceed 400 feet. Do you want the code section, Karen?
No, that's okay. I
Okay.
can get it from you later, but all right, so
Karen, does the noticing allow for any and all variances that the board may deem necessary?
yes, that's my understanding. That
It does.
the applicant
Okay.
included a provision to that effect.
Okay, thank you.
And Mr. Cohen, I have a question for Mr. Ingram as well. Jim Purcell here.
Sure.
Wayne, you testified that you're going to put in a rain garden. It isn't showing up on this plan that we're looking at, obviously, because it's a variance plan. Can you point out again where that rain garden will be?
Sure. Yeah, this is referring to sheet 1, which was just the variance plan sheet. Sheet 2 of the provided plans has the grading and utilities all on there. The rain garden is shown. It's on the basically and northeast of the house, right where you see kind of the edge of woods designation there at the just again to the north of the house. It's going in that area. So obviously slightly downhill of the house so that we can connect all the roof leaders via gravity. And again, that we believe that is sized to meet the municipal standards.
Okay. Obviously, I'll be reviewing that when you submit for your zoning permit. Thank you.
Mr. Ingram, just for clarification, I don't know if another witness will address this, but is it feasible for the applicant to acquire any additional land to increase the lot width?
Lot width, I don't believe so. There are homes on all the other properties that would allow that.
Okay.
No, not without expanding or causing another non-conforming condition, because we would have to go out from lot 18.
Okay, thank you.
Could I ask a quick question, Eve Colson, about the fire hydrant? Is that the distance issue? Is that a zoning requirement, or does that come from the fire department, or?
Eve, that is a zoning requirement.
Oh, okay. I wondered because I'd never heard that before, and I thought,
It's for flag lots specifically.
oh,
It's for the requirements for flag lots.
okay. We don't have those all that often. Thanks a lot.
No problem.
Okay, please continue.
All right, and so we have our planner. I don't see her. Oh, there we go. All right. Just introduce yourself and provide your qualifications for the board.
Hi, everybody. Susan Pavati with BFJ Planning. I have a master's in urban planning from New York University, and I've been a professional planner for just over 20 years here in the New York, New Jersey metropolitan region. I am a licensed professional planner in the state of New Jersey, as well as a member of the American Institute of Certified Planners. All those licenses are in good standing. I previously testified before this board just a few years ago, as well as the Princeton Planning Board and various other planning boards, primarily in northern New Jersey. Also,
Accept you as an expert.
okay, thank you. So I'm here to speak about the variances. What you have heard so far tonight, I think it makes very clear that this is an unusual lot. A lot of interesting factors really, relate to the variances here. And I'm going to speak mainly to the garage and the wall articulation variances. We have talked about the existing nonconformity of the lot width, where 175 feet is required, 107 feet exists. As you just heard, there's really nothing that the applicant can do about that as a pre-existing condition that affects the current house as well. So in terms of the newly created or exacerbated variances, you heard about the location of the garage, the code requiring that the side garages be set back from the main facade of the house by 8 feet. Here, in this case, our garage is in front of the facade. Similarly, the width of the garage is limited to no more than 50% of the width of the house, and we exceed that, as you'll hear why. And then lastly, on the wall articulation variance, you heard that the side-facing wall facade is limited to 40 feet in unbroken facade, and we slightly exceed that. So I'm going to argue here that these are C1 variances, C1 hardship variances, and they really all stem from the kind of peculiar configuration of this lot and its status as a flag lot. So as you've kind of, I think, gotten a sense so far, this lot really kind of reads as fronting along Henderson Avenue, except that Henderson Avenue is not a street. And in fact, the official technical frontage of the lot, because it's a flag lot, is Mountain Avenue. So it's sort of perpendicular to the Henderson Avenue property line. And so that really does create the conditions for these variances in combination with the sort of onerous or more restrictive flag lot setbacks, as well as the environmental constraints on the rear portion of the lot. You saw that we have a wetland buffer to deal with. We have steep slopes. We have vegetated areas, all of which leads to a pretty small footprint and essentially requires a very wide and shallow home. And that directly leads to the requested variances. So as it pertains to the location of the garage, because that front yard is technically the lot that faces Mountain Avenue, even though it is at least 300 feet away from Mountain Avenue, it's really not possible to avoid this variance and keep the garage on the same side of the house. If the garage were relocated to the other side of the house, which would obviously eliminate that variance condition, it would require additional impervious coverage to extend the driveway to get to that garage. And that would also place more of the bulk of the home closer to the closest neighboring lot line, because the entire home would shift and the two-story portion would be closer to that neighboring property line. So we do think that maintaining the garage in its basic current configuration, at least on the same side of the house as it currently exists, is a preferable condition. With regard to the width of the garage, again, it's very strange because the front lot line is technically facing Mountain Avenue. So when we say the width of the garage, that is the portion of the garage that is along Henderson Avenue. I'm sorry, it's perpendicular to Henderson Avenue. So it actually functions more as the depth of the garage in terms of where the cars will actually be. That is a depth measurement. And so the shallowness of this home, which again is driven by the small building footprint, really limits how long that garage width can be, to about 19 feet, which is really not functional for garage that you would actually use to store a car in. And this is, again, entirely due to the configuration of this lot. It makes it nearly impossible to meet this standard and still have a functional garage. It's also worth noting, as I think you've heard throughout this presentation, that the existing home does not meet either of these garage regulations. And in fact, the proposed home will improve the condition because it will move the garage to 42 feet off the property line with the neighboring home, as opposed to just under 7 feet. And that, together with the privacy fence that is proposed along the property line, as well as the features of that garage wall itself, which features windows and different paneling materials, all of that serves to break up the garage wall that is facing Mountain Avenue and helps to mitigate the visual impact of that, as well as the fact that it is a single-story portion of the home. And then lastly, when it comes to the wall articulation variance, this again is unique to this property because there is this requirement that walls not facing a street, i.e. the side walls, not exceed 40 feet. And we again are at 42.67 feet, just a little bit over that measurement. Again, but the house is reading more as frontage along Henderson Avenue, which, as you saw, has other homes along the corridor that exceed 40 feet. So it's a fairly minor deviation. And again, the building design and materiality help to mitigate this impact. This is a single-story portion of the home. You saw in the architectural renderings that it does have articulation that really breaks up that facade, and we think really mitigates the technical deviation for that variance. And then the last variance, which came up tonight, is the fire hydrant variance. So as you just heard, we do exceed the allowable distance for a flag lot to be located from an existing hydrant. The existing home also exceeds that condition. So we're exacerbating a bit by extending the house another 35 feet away from the property line. We think that that's a preferable impact to again eliminate a non-conforming setback issue and move that house further away from the neighboring property owner. It's also worth noting that the fire safety official has reviewed this application, had no concerns regarding this application. If anything comes up with regard to the hydrant or any other fire safety issue, we're happy to coordinate with them accordingly. But that is technically a variance because we do not meet it now and we're exacerbating that condition. So I think that
note on that point, I just want to confirm with the zoning officer, just can we confirm that we have that confirmation from the fire official?
Yeah, I can confirm that.
As they reviewed and had no comments or raise any potential conditions of approval.
Mr. Diamore stated, the structure does not appear to have any such risk factor as such. This office has no comments at this time.
Okay.
Great. Thank you, Anthony.
No, thank you.
In summary, looking at the variances that we were requesting, most of them really don't relate to this particular property. They don't fit, as you saw in Mr. Grace's presentation, they don't really pertain to this type of lot. We have a lot of unique situation here. Everything about the property and the proposed house is oriented toward Henderson Avenue, but because it's a flag lot and the front yard is technically along Mountain Avenue, it really does create those variance conditions. It's not really possible to meet all of those standards. And so that is a hardship that exists with this property. It's not self-created. I think that these variances would be a factor in any new home that was built here. And of course, they are a factor in the existing home as well, at least the garage variances. So that's the C1 portion of the variance testimony. We also have to look at the negative criteria, which is meant to show that the granting of these variances can be granted without causing a substantial detriment to the public good and will not substantially impair the intent and purposes of either the municipal zoning plan or the ordinances. So again, just want to note that with the exception of the existing non-conforming lot width, the proposed new home will meet all of the primary bulk standards: lot area, setbacks, height, coverage, etc. And it also importantly eliminates the existing front setback nonconformity by, again, moving the house about 36 feet more into the interior of the lot and then reducing the impacts on the closest neighbor to the southeast, which is lot 16. So as I've discussed, hopefully it's becoming very clear. The three new variances that are stemming from this being a flag lot, which are the two garage-related variances, as well as the wall articulation variance, and as well the hydrant issue. They're all a function of where the structure can be located on the property, how limited that building footprint actually is, the environmental constraints on the rear portion of that property. These are all conditions that really can't be controlled or changed depending on how you design this home. So granting of these variances would not substantially harm the overall public good. It would not have create negative impacts on the adjacent or nearby properties. In fact, we are lessening the impact on the closest property, the closest neighbor. The home will be continue to be oriented as it is today. The current home is on Henderson Avenue. The garage facing this roadway is set back from the facade in a comparable ratio to what the current house is as well. And the new home will use articulation, high quality natural colored materials to minimize visual impact. So looking at the zone plan and the municipal ordinances, we did review the master plan. There is not anything in the master plan or this application that we believe is inconsistent with the master plan. And the proposed home is also consistent with Princeton's zone plan. Again, because primarily, or I would say all of those bulk variances except for lot width are met by this new home. And it reduces one of the nonconformities. Looking at the public benefit, this new home represents a really nice investment into this neighborhood, an upgrade from the existing house by owner occupants who you heard testimony from intend to live here for the long term and to be part of this community. It's an upgrade from the existing house, which is showing some age and some issues with its current condition. And this new home is designed in such a way to blend in with the natural surroundings, minimize impacts on adjacent properties, and preserve natural features. It is a larger home than what currently exists, and that is typically what we would see when you replace existing housing stock, but it does comply with FAR, building coverage, height to setback ratio requirements, and in fact is proposed at a much lower height than what is allowed by the zoning code. There are other large, newer homes in the vicinity of this house, and so this proposal really does represent kind of a nice transition from those large structures which are nearby to other homes on Henderson Avenue, which are a little bit more modest in scale. And then lastly, again, it does reduce or eliminate the existing front yard nonconformity. So in summary, looking at the negative criteria, we do submit and believe that the benefits of granting these requested variances would clearly outweigh any potential detriments. And with that, I will be happy to entertain questions.
Board members, any questions? Okay, Mr. Tadaro, please continue.
Yes, no, that appreciate it. Thank you very much. That concludes our direct presentation tonight. We heard from all of our professionals as well as the applicants. Again, we really appreciate the opportunity, and we'd like to answer any remaining questions you might have or anyone in attendance tonight.
Okay, board members, do you have any question of the applicant or the witnesses?
I have a question. What's the
Please.
square footage of the garage?
We'll pull up that number for you. Let's see here. Mr. Grace, you have it handy by chance?
I'm calculating it as we speak.
Okay.
Give me 1 second. The overall square footage of the garage is approximately 1,080 feet.
Okay. And did you ever look at just rotating the garage so that the garage doors didn't face, I guess they would have to face Mountain Avenue instead of Henderson?
So we did consider that briefly at the outset of the project. I think the challenge there is to get even just a 2-car garage in that configuration, you would still be exceeding the more than 50% of the width of the overall structure on that side. I guess technically then it would be a front-facing garage. because it would be facing the Mountain Avenue, but it would actually really be directly facing a neighbor by rotating it 90 degrees as well. By orienting it this way, it really more so faces the interior of the lot. It is a narrow lot, and interior is a relative term, but it really faces the interior of the lot when oriented in this fashion, rather than if it were rotated 90 degrees, it would be facing towards the property boundary.
Okay, thank you. Is it an abnormally large garage? I mean, it looks like it's a story and a half, at least.
The overall height is 13 feet above grade. So it's a bit taller than on the standard story. The clear, below structure, the clear height would be less than 12 feet.
Okay. But is it abnormally large in your estimation?
It's a 3-bay garage, so a 3-bay garage, and it does accommodate an interior ramp. I'm gonna put the exhibit back up just to show the floor plan. Here you see it. It is 3 bays wide. It doesn't accommodate an interior ramp to allow for mobility, better mobility over time. But it is a 1-story structure.
And it's 27 feet deep. Is that correct?
27 is overall depth. Yeah, the interior clear dimension would be closer to 25 feet.
It may be, Stephen, it may be a little bit deeper than a normal garage, but it allows for 3 cars, good access to 3 cars and storage in the back, on the back wall of the garage.
No, I don't think there's an issue with it. It just looks like an awfully big garage compared to the rest of the house. And I was just reflecting on that. That's all. Thank you.
Okay, board members, any other questions of the owner or the applicant or the witnesses? Okay, so at this point, we're going to allow Mr. Tadero to make a statement prior to us going into opening the hearing to the public.
No, again, just appreciate the board's time here tonight. We took a little while to get here. We're very excited. We were actually able to get a decision from the Court of New Jersey that alleviated the need for 2 variances and cleaned up some of the title issues. That way, we didn't have to present those additional proofs to the court, to the board, and have to deal with some type of question as to ownership and our ability to use Henderson Avenue. So I think what we've presented is a very reasonable and purposeful project that's mindful of the existing conditions and any of the impacts to the neighbors.
Okay, all right. Taylor, is there anyone in the audience has indicated they may want to speak on behalf of this application? And just to the audience, if there's anyone that does want to speak to this application, please indicate that by pressing the raise your hand button on the bottom of the screen, and we will acknowledge you and allow you to speak. Is that okay? So we need
3
okay.
people.
Okay, please let them in one at a time.
I might have let more than one in at the same time.
Okay.
Well, we need to ask these members of the public, can you get your video operational, please, and your audio?
Yeah.
Great, great.
And we'll just make clear here, George is.
Good evening.
George,
Thanks for the chance to speak before you. And thank you to the zoning board members for your work. My name is Jeff Brenner, and this is my partner, Kathy Stillo. We live on Henderson Avenue, 19 Henderson Avenue. We're one property away.
We're 15 Henderson.
I'm sorry, 15 Henderson Avenue. And Kathy has lived here for 23 years. We have some slides that we would like to be able to talk through. We did submit them to the board. Should we share them, or is it better for you to share them?
You can share them with us.
Mr. Brenner, just for clarification, which slides are you sharing? You had a couple of sets of documents that you provided. There's one called requested conditions of approval. That's it. Okay, very good. And we will mark this, I guess, objector one. How about that?
We're not sharing, our video's not on.
Ms. Casey,
Are you able to see our slides?
Yes.
Yes.
Great.
Get a clarification?
And can you see us as well?
Yes, we can.
Okay, great.
Great.
Can I just, before they begin, can I just,
we're incredibly
clarification?
excited about the Haydas house. They've designed a beautiful house. Helena and Boris are welcome to the neighborhood. We're not here to object to a new house in the neighborhood, and we're excited about what they've designed and put together. Over the last 100 years, the Henderson family that owned all of this property made a lot of decisions. They created an 800-foot road through this property. They subdivided into multiple different lots. They built homes, and there were utilities placed. And this application has brushed over a lot of those details. And we have serious concerns about safety and access. And many decisions were made along the way by zoning, planning, by the municipality, by property owners that need to be considered and taken into account. So I want to walk through a few of those things that we're concerned about. Just to remind the zoning board, while the judge has decided that the applicants own Henderson Avenue,
Wait, we can't have two people talking.
Lots get easement of necessity.
Wait,
There's still
Mr.
are 4 more properties. So we
we
would
gotta
ask
work
that
on
the
a legal-
zoning
Wait a
board
second. Hold on for a
not fully
second,
permit
please.
this and let this go.
We've got to have, we're getting two conversations in here.
Yeah. In this case, I was trying to get in before they presented their slide. I have a legal issue I want to address with you. Just for clarification in the record, I believe that there was an attorney of record who entered his appearance on behalf of many of the neighbors, including Ms. Stillo, not Mr. Brenner. So I just wanted to get that clarification as to whether they're being represented tonight. I don't see him here. Just so I could get an understanding as to what they're going to be presenting to individually as neighbors, or if there's going to be an attorney of record.
Oh, you're muted, Mr. Brenner.
That did not appear on the tax map by accident. There must have been some action.
No.
At some
No,
Wait a
Mr. Brenner,
second.
Someone in the
just before
municipality, the
Mr. Brenner,
former owners of the property must have taken some action to create this. There must have been some vote.
Can you wait? Can
of
you
the
stop
planning,
for a second,
zoning, or
please?
municipality. There must have
Can
been
you
some.
hear us,
plan-
Mr. Brenner?
Can you hear
I don't know if
us?
you hear us.
Well, we can hear you, but I don't know if you can hear us. The attorney for the applicants has raised a question. He asked,
I'm sorry,
You're-
we
someone's
must have lost
attorney-
audio for a few minutes there.
say again, please.
We must have lost audio for a few minutes.
Okay, Mr. Tadara, could you repeat your question?
Absolutely. So there was an attorney who entered his appearance of record on behalf of several neighbors, including Ms. Stillo, but not Mr. Brenner. I don't see him here tonight. So I want to make sure that the record's clear, and for clarification for our end, whether the neighbors are going to be presenting individually on their own behalf, or if there's going to be an attorney who's going to be representing them tonight.
We're
representing ourselves.
We're presenting individually tonight.
Okay, thank you.
I'm sorry, where did we leave off? Because I think we lost our audio there.
Yeah, the last thing I remember you saying was, what's happened over the years, Henderson family created roads, subdivided out lots, created utilities, and then you kind of drifted off there.
I'm sorry.
So at some point, the Henderson family and the prior owners of the Haydes property must have submitted paperwork to zoning, planning, the municipality, submitted to Mercer County a plat. As properties were subdivided, this road was created for a reason. There was also an action of the municipality in 1949 to create a sewer ordinance. There's a gas line, water line, power line through this property as well. And the back lot, lot 10, was created. So there were a lot of actions along the way that need to be taken into account here. Just to give you a sense of the road, the actual pavement of the road is only 14 feet wide and is an incredibly narrow road. It's hard to turn around. You actually have to pull into the driveways to be able to turn around. On the right-hand side, what you see is a picture of the Haydes mailbox. It says 25 Henderson Avenue. By the definition of a flag lot, it says to be considered a flag lot, the lot shall have no other frontage except for the end of the pole portion. That's 25 Henderson, what it says on the Haydes mailbox. For 40 years, all of us have gotten mail right on Henderson Avenue, including the Haydes, have gotten deliveries. And if you come by the house, it's very clear that the house fronts and has always fronted onto Henderson Avenue. So it's a sort of an erasure of the existence of this road. This mailbox would have a Mountain Avenue address, and this property would have been, all of us would be getting delivery of our mail out on Mountain Avenue. At the bottom, you see the Amazon truck turning around in the Haydes driveway. It just gives you a sense of how narrow this road is. And we're very concerned that if they own the entire road, that the zoning board protect us and make sure there's not a gate or an obstruction put up anywhere, because then their own mail truck is going to have to back out of the road. So the delivery trucks come down the road, deliver to that property, and then turn around. So we think it's really important as a condition of this property that the road remain open, the driveway remain open, and that there not be any gates there either. So as we said, we're not trying to obstruct the building of this property. It's a beautiful property with some small changes. We think the neighbors would be protected and safe, and the Haydes would be welcome. This road is a road, and it should remain a road. And the full length of the road actually serves the back lot and serves two lots, and I'll show you that in a second. As I said, we don't want to see any gates or obstructions on the road, that all of this get locked down before building start, that we get really clear that the frontage of the property is on Henderson Avenue, the full Henderson Avenue, and the houses should be even along Henderson Avenue. As you guys know, there's an ordinance for a non-flag lot that the front of the homes line up. It's going to be very strange to have one house moved up across the line of the homes. I realize if we accept this as a flag lot, that they're allowed to move it up, but we think if you moved this back 10 or 15 feet, it would keep the utilities that are underground there safe, and it would also be in line with the other houses. Recognizing this is a very odd situation, it's not a true flag lot. It's a very strangely structured lot. We want a clear construction management plan because they are going to be on top of utilities that serve all the neighbors, including a lot directly across the street. So if you go to bury that electric line, it also serves the neighbor across the street. And the sewer line, the water line, the gas line, that is our shared utility, including the property right across the street. So this is a picture of the Haydes lawn with PSC&G truck pulled up on it to trim the utilities that don't just serve the Haydes, serve the property across the way. So, we can't emphasize enough the degree to which this was was approved at some point as a road with lots of utilities placed along it. I realize it's a private right of way, but it's a right of way that we all share and we need in order to serve these utilities appropriately. This is a picture of where the driveway is. We would want to make sure that the fence, as it's shown in the picture, doesn't come past the front of the garage, and that the actual terminus of the paved driveway is pretty far. So if you follow along Henderson Avenue, way on the left, those two bushes is actually where the current pavement ends. So their driveway basically digs up the end of our road that we've all had for 50 years. So, and turns it into their driveway. Because the judge has decided it's privately owned, they could at any point gate that or do anything they want. If you look beneath,
I'm gonna object just because I'm not sure if we're talking about issues limited to lot 15, or if we're talking about issues that could potentially be impacting other properties.
that's fair, but we're so on top of each other that if a fire occurs or a safety issue occurs for one property, we're all so close to each other, it affects all of us. Or if something's impairing access to one property, it affects all of our property values. I think this is just general safety, and the goal of the zoning board is to ensure that good decisions are made so we're all safe. And we're all on top of each other. It's a very dense neighborhood. So
Okay. Please continue, yeah.
Directly across from this driveway, where it says frontage of 22 Henderson in a red box, there's a house right there. So that turns that street right now, it turns half of the frontage of their property into a private driveway. And they haven't been given an easement of necessity, so that's messy. And then to the left is another house that's essentially stranded. If you look at that property, there's a 10-foot easement in the back of the property that exits out to Mountain Avenue between two homes that are only 10 to 12 feet apart. So the back of that property doesn't have appropriate access. The only access to put out fire, to pick up trash, to access that property is along Henderson Avenue. If you turn that into private driveway, you can't appropriately get to that home. That home currently puts the trash out there. So eliminating this road and turning a third of it into a private access driveway really impacts neighbors in a detrimental way.
Ms. Case, can we have those neighbors are here tonight. Can we have them address the impacts of their own property?
They will. This is the original sewer ordinance passed in 1949. There had to have been a lot of work by the property owners, the former owners of the Haydes property, to get this done. So there's been many steps of municipal action. That sewer line goes through the front of the Haydes yard. There's actually a manhole cover 15 feet from their front door, a public sewer manhole cover. There are all the sewers buried, all the utility lines buried right in their front yard. So this is a picture of the manhole cover in the Haydes front yard. That's Princeton Municipal Sewer Line. The PSE&G and water line that serves all of us is 5 to 10 feet in front of them. If this is a substantial house, we need to know all those lines are protected. And as has already been cited, is 400 feet from the nearest hydrant. The current house is a small house. This is a beautiful large home. We support it, but there's substantially more fire hazard to put out an enormous fire on a 14-foot wide road that's more than 400 feet from a hydrant with limited access for the property across the street. We think before the board approves this, the municipal engineer with the fire official, together with your zoning official, should walk down the road and look at all the access and walk into the back of some of these properties and see what the access looks like to make sure that you fully understand what we're all getting into. The last piece that I'd like to close on is, if you look at this, lot 10 way back in the back is essentially a stranded lot. So when lot 10 was subdivided, it depended on the road that was created by the Haydas, the folks that owned that property. The access for lot 10 is actually a very strange 3-foot by 29-foot access point that then connects into this 10-foot road that goes down to Mountain Avenue. So before you approve all this, your zoning official should walk the road back there and make sure that you haven't stranded lot 10, and then look at the other property that's further up, and make sure you haven't stranded them as well. So I'll close with one final point, which is we think that once you make this a flag lot, you're counting the pole in the FAR calculation. You're also counting it in lot size. It's really 1.2 acres and doesn't hit the 1.5 acres to fit in with R2. So that's it. That's all that we have to say. Thank you very much for listening to us.
Thank you.
I'd also like to make a statement, but I'm willing to wait to give my neighbors a turn first. So just let me know what order we should go in.
Dave, do you want to hear from the other neighbors first?
Let's hear from all the people in the public, and then we'll board members, do you want to question this neighbor who just spoke? Okay, please
If I may,
continue.
Ms. Still is already on, so it might make more sense just for timing purposes. She's
Okay.
ready.
Sure. Yep. So just a few thoughts. I'd just like to say that my name is Kathleen Stillo. I live at 15 Henderson Avenue with my partner, Jeff, and I've been here for 23 years. So whatever the board decides about the house itself, the one thing this approval must not do is allow Henderson Avenue to stop functioning as a road. And that risk is not hypothetical. The applicant's own site plan removes the existing driveway. We saw that. It cuts a new angled driveway across the road with a 6-foot board fencing at its edge. And all of that is labeled on the maps that we saw earlier today. So that is why we're asking for these conditions, not denial, but just conditions on an approval. No gate or barrier ever. The road be kept open at its full width. These protections put in a recorded instrument, I think you call them conditions. I'm not in this industry, I'm in healthcare. But conditions in order to get approval of the variance requested. And then the construction management plan that Jeff alluded to, because this same narrow road is the only emergency access for families who live on it. And while heavy equipment is working above our water and our sewer mains, that really puts us in jeopardy as well. So I want to be really direct about my biggest worry. With this road being only 22 feet wide, it can't be blocked at the southern end or at the northern end. And in a neighborhood this dense, a fire at one house reaches the next houses within minutes. And the nearest hydrant we've talked about is more than 400 feet away. A fire truck has to be able to reach every one of our lots every time. And this isn't abstract for me. During Hurricane Sandy, a 70-foot tree came down on my house, and the emergency crews worked on this road for hours removing that tree. So every house needs access, and we also lose power more often than it seems the rest of Princeton does. I think that's because we're a private road. So again, like utility trucks are here more often than you would think. Second, the design. So the application treats Mountain Avenue as the end of the pole, quote unquote, as the front of this lot, and declares the prevailing setback rule not applicable. But every house on the eastern side, my side of Henderson Avenue, holds that front door line, that setback line. And the new design projects roughly 13 feet out in front of that line toward the road. And I'd ask the board to just require that this house, the new house, front on Henderson, just like all the others, with its facade lined up. And the variances the applications the applicants do concede they need are self-created. This is a brand new house on a supposedly 1.5 acre lot. A garage placed in front of a home where the ordinance requires it recessed behind the facade, but that's not how it's set up here. The garage is wider. We heard a lot about that earlier. And overall, the sidewall is over length as well, but nothing about this forces any of that, meaning a fully conforming design does fit here, or simply move the current design back so that the extra 13 feet lands in the backyard instead of in the front yard. So again, we're not opposed to the Haydas building a new home. We welcome new construction here at Henderson Avenue. I want the board to know I plan to age in place here, and it's a key part of my retirement plan, this house. And Jeff and I are not leaving, which is exactly why these protections need to be recorded and permanent. We're asking the board to make sure it isn't built at the expense of only the 8 other families who are on the road. And a private road can be privately held in Princeton. That does not mean the homes that depend on it can be cut off by gates or private driveways or any other means. If the conditions can't be settled tonight, we'd respectfully ask that the application be carried while the court-ordered mediation over the road is still underway. And thank you very much. We appreciate your time, and we're available for questions.
Thank you. Board members, any questions?
I guess I have questions just on some of the issues they raised, because I would have expected that the court would have resolved the issues of the road not being able to be gated, things that it would come up and it'd have a resolution prior to our meeting. So I guess my question is ultimately going to be to the applicant's attorney and to Karen. And then the second thing, this application before us, and maybe this is to Taylor and Karen, is the intrusion of the driveway into Henderson something we're approving? And then of course we do have engineer here now. He can weigh in on a couple of things, or we can possibly, as was requested, postpone it. But I don't know the answers to the initial questions I asked. Because these are big.
Michael, I don't know, Mr. Tadara, do you want to respond, or do you want
Absolutely.
me?
So,
Okay.
so to address the court issues, the litigation's ongoing. What has been resolved is the issue of ownership. The various easement rights by the neighbors is something that the court is still within the jurisdiction of the court, and the court has told all of the parties to submit the mediation. And so that's ongoing. It's either going to be resolved amicably or by another decision, just like ownership was. That has no impact on whether we could proceed tonight. Quite frankly, we could have proceeded prior to. It just makes the application a lot cleaner.
Well,
so
go ahead.
Yep. And there's no gate or other barrier proposed in connection with the application. So I think that really addresses those issues. The easements are still, like I said, it's something before the court to be resolved outside of the board process. But anybody who has easements is easements by necessity here, including Ms. Stillo and Mr. Brenner's property. I mean, we, by law, we're not able to block those off. So.
Okay. Karen, I do have another question, I guess. The differentiation between it being a private road and
versus a public road? And if it's a private road, what say do we have, or the municipality has, regarding some of the issues raised by this first neighbor? I mean, I'm not sure we have any say if it's a private road, but I don't know.
It's
Taylor.
It's not public. It's clearly
I'm
private.
directing that question to Karen, please.
Oh, my apologies.
I'm sorry.
I think, Michael, there are a number of private roads in Princeton. I think from the municipality's point of view, and my understanding from reading the court decision, is that the prior owners of the property that's before you tonight had entered into a utility sewer agreement with Princeton. They had also entered into utility agreements with PSE&G. So the court's decision, to the, as far as it goes at this point, recognizes that there are other issues to be addressed. And the court pretty much ends its decision by saying it's most likely that some or all of the neighboring defendants, and the court makes a distinction between the neighbors who the court has found have an easement by necessity. They must be allowed to travel down Henderson to get to their home. Then the court finds there are other properties who have an alleyway access that I think Mr. Breno and Ms. Stilo referenced. And to those defendants, looks like the court is saying, well, it may be that they have rights to access Henderson as well, but that there was not enough information provided and all the parties were sent back into mediation. And I assume if not resolved, they will have to come back to the court. So we have an unusual situation in which we have a court that's currently hearing, and I'm assuming will address legitimate issues that are being raised regarding continued access, utility easement access. And my concern is that, we sort of have a higher power that's currently considering these issues. So I appreciate the applicant feels that none of these will impact the variances that they seek tonight from you. And at this juncture, the board either can continue, hear the application tonight, render its decision. I know a couple of members have indicated maybe they want to wait to see what is the court going to do. Is the court going to address these issues? Because I'm assuming that the neighbors, and we don't have all of them here tonight, but that those that choose to participate in mediation will raise these issues and ask that they be resolved then by the court. Because, and now I will ask Mr. Tadera, maybe he can provide a clarification. Since some of the neighbors, it's been found by the court that they have an easement by necessity, is it fair for us to assume then that you can't block their access, and the same thing that you would not interfere with their utilities? Is that a fair conclusion, or?
Yeah, I suppose. I mean, I think what we're struggling here is we're not proposing any changes at all. I mean, they have an easement by necessity for access. That the utilities that are out there, they're out there, and there's no impact to those as either. We're tying in right at the flag portion of our lot. And there's no gate or other barrier being proposed that would drop down over to that intersection of Henderson and Mountain Avenue, if that's what you're asking.
I heard something different. I mean, I just want to throw in that for one thing is this doesn't strike me as being just a simple private road, because I think a private road can be one in which everybody sort of equally participates in it being part of it. This is like privately held, right? It's not that simple. So that means that one person who lives there does have powers that the rest do not. And the other thing that I heard, which is which sounds like the concern, not that there would be a gate at Henderson, but that there could be a gate or an obstruction that would make it impossible for either emergency vehicles or delivery vehicles to do what they have been doing lately. And that just may not have been taken into account since the Haydas don't live there. They may not be aware that that's what's been done. So those are two things that I wanted to bring up. Am I right? I mean, I think a private road is something other than this. This is privately held.
Yeah, well, I live on a private street, and we have a neighborhood association made up of all the lot owners. It's a little different situation. The street is owned in common. Mr. Tadero, by virtue of the fact that your client will own the street, they're going to maintain it, I assume. They're going to handle the repaving, they're going to handle the plowing and any maintenance it needs. Is that correct?
It's theirs. The thing is, and this is where it came up, is that there's certain neighbors who tie in from their driveways and use Henderson Avenue. Over time, as lots were created, rather than setting up a neighborhood scheme or all of the neighbors having express easement agreements, there was nothing. And so now it's on the owner of 25 Henderson, which is the lot that has all of Henderson Avenue, to sort through it all.
Mr. Tadaro, that's not fair. We could have settled this over a glass of wine in the driveway.
Okay, excuse me.
No. That's not productive to have a
Let's
tit
not-
for tat here.
No, there's no, let me just ask a question. Is this, just back to my issue of who's going to maintain this private road? Is it your client's intention that he now, and assuming ownership of this, will maintain it?
So the owner, it's their property, and all owners have an obligation to maintain their own property. We agree with that. Anybody who has an easement, I mean, with the benefits of having easement rights also come the burdens of sharing in that maintenance. And that's just by law.
But wait, they'll have an easement to use it. Correct. But it's still owned by a private entity.
Correct.
So
That's
the private entity maintains the roadway.
Ultimately, it falls on the property owner of 25 Henderson to maintain it. And then everyone else would share in that obligation if they have easement rights. If they're using it, then they would have to kick in for the maintenance.
Mr. Tadero, you're talking then about them making a payment to the Haydas, correct? Towards the cost of snow plowing, road paving, etc. Is that what you're saying?
However it's made out, however it works itself out.
It hasn't been decided.
No.
Right. So you can't say what it can be. And I think it's just one of what may be a growing list of things to be worked out in mediation. I think this is premature to be here simply. And if a number of people agree with me, then let's,
Michael, I agree.
What we have here is we have a very set number of variances that are dealing with facade and lot width and have nothing to do with.
I do not care about that. It's not settled. It's still in litigation. that was a condition that we haven't heard it, completed it up till now. It's come here half-ass. It's not settled. There's a lot of things that aren't decided.
And I assume, to Michael's point, I assume that even if we acted on the request of the applicant in terms of variances and things like that, no construction could take place until this roadway determination and access was all resolved, I assume.
No,
I can't speak to that only because with a court order saying that the court finds they own the road.
Well, to address that specifically, the condition of approval, should the board be inclined, was that we show proof to the board attorney's satisfaction as to a legal right for access of Henderson Avenue. And the most paramount way to do so was a decision by a Superior Court judge in New Jersey who said, oh, absolutely. All of Henderson Avenue is part of 25 Henderson.
But it didn't discuss maintenance, it didn't discuss paving, any of those things. Which you're saying, which you're intimating is going to be handled, is going to be a shared responsibility.
Right.
Am I wrong?
And that's what's still within the court's jurisdiction.
Okay, so isn't coming to us at this point before that's resolved? Isn't that?
We don't think so. No, because it has no bearing on what we're coming to the board to do. It's, if anything, quite frankly, we had one of our neighbors' application, and they actually needed access through Henderson Avenue. We didn't oppose it. We're fine with it.
But Mr. Tadero, they are one of the properties that the court finds has an easement by necessity, correct?
Correct.
Okay.
And there was
So
no
when
issue.
the court is directing you, they're saying
allowing-
you must provide access to them. So, Steve,
Yes.
since there are other property owner, there are other residents, I believe they're all on Henderson Avenue, who I think want to speak. Do you want to hear from them too, or do you want to?
No, I think we can, they're here tonight. I think we can hear from them. Whether we continue afterwards
Right.
is another issue. Sure. So I would think let's call the next person. I only see one other hand raised.
Is that Mr. Burns?
Yes,
Yeah,
it
there
is.
are four more waiting, but
Okay.
Mr. Burns is.
Okay.
All right, so let's hear from Mr. Burns.
Mr. Burns, can you turn on your video, please, and your audio?
Okay, can you hear me?
We can
Yes,
hear
but
you.
we-
We need to see you now.
Yeah, right. Let's see, where is my video? Maybe this is it. Join as panelist.
Yep.
You're muted again, but we still can't see you.
Unmute and start video. Okay, I should be good here. Nope.
We still don't see you.
There you go. Great.
Okay.
Okay,
Right. Thank you for that help.
Mr. Burns, do you swear from your testimony this evening will be truthful?
Yes, I do.
Thank you. And could you give us your address, please, if you're comfortable with that?
Sure. It's 30 Henderson Avenue.
Okay. Thank you.
How's my volume? Am I
It's
loud?
We can hear you. I can hear you anyway.
Okay.
It's fine.
All right, thanks. Shall I start?
Yes, please.
Okay. Partly I'm going to read it just because that'll help me. My concern with the zoning variance application is that it proposes to reduce the extent of Henderson Avenue. So I'll just say much of this is is similar to what you've just heard. There are already some risks in the neighborhood as the road is not available to certain lots, including my own lot, which is lot 17. This limits access to services of all kinds, and most seriously, emergency services. Rather than reduce the road, which is implicit in the zoning variance application that I saw, the road was getting reduced by about 46 feet. Rather than reduce the road, we should maintain and protect it, giving it priority over personal uses. And I'll just say in this sort of an addendum to that little paragraph, my lot is lot 17 and the address is 30 Henderson Avenue. It's not even shown in the presentation, but it is, I've lived there for 30 some years and I've always had this address. And like my neighbor to the north, who the Vogels at lot 10, they too have a Henderson Avenue address. So the existence of the road is kind of part and parcel of our reality. And that's really pretty much ignored by the presentation we just saw. The existing conditions of Henderson Avenue. It serves 5 lots. It doesn't serve 2. The 2 of them speaking of are lot 17 and lot 10. I'm sure I don't need to point out, but I will perhaps redundantly point out that roads in general serve a multitude of functions, including utilities, pedestrian access, vehicle access of all kinds, government and commercial services, as well as miscellaneous other things, including social purposes. At present, Henderson Avenue terminates with a 2.5-foot overlap with my lot. And that allows me to take advantage of Henderson for a few functions. It's not enough for emergency services, but it allows me to put out trash and recycling, and people come up and park there. So I have a kind of equivocal relationship to Henderson. Henderson is, just a few facts, 885 feet roughly, all from mountain up to the very northern extent of lot 11. It's paved for 331 feet. And that's the slight overlap with my lot that I mentioned. Utilities extend past the end of the paving in the center of Henderson. So the above ground utilities go 90 feet past that point, and below ground goes 60 feet past it. So I guess the case I'm making is the existence of Henderson Avenue. It certainly is debatable, but it exists, and part of that existence is the utilities, part of it is the properties, now lot 10 and lot 17, my own, which have Henderson Avenue addresses. And then finally, those 2 lots have only access via a 10-foot easement through our backyards. And I went down and measured it today, and it's even slightly less than that. But the chance that a fire truck might not come through that dimension seems real to me. And so we will, Iowa anyway, and probably the Vogels in lot 10, will be pursuing this easement by necessity and think that Henderson should be our access as well, and it would clean up the whole area and make sense of it, and make it more safe. Let's see. I think I've said it pretty well. Basically, I'm arguing for continuation and a protection of Henderson Avenue because it serves two lots, and in fact, it serves the Haydas. That is, they have a long lot, and if in fact they terminate, they shorten Henderson by 46 feet, and they have a driveway at the very southern end of their lot. If anything ever goes wrong at the far northern end, they have no access down there, or no guaranteed access. Whereas if we keep the road open, as both Kathy Stillo and Jeff Brenner were arguing as well, they will have a way to get emergency services throughout their lot, and so will the Vogels in lot 10. And I think that's if you have any questions, I'd love to answer them, and thank you for listening.
You're welcome. Board members, any questions of this neighbor?
I have a question, Steve.
Sure, go ahead.
Mr. Burns, I'm looking at Google Maps and I see a car in the back of your house. I don't see any driveway to Henderson Avenue. Do you have a driveway to Henderson Avenue?
I do not. No, the paving ends 2.5 feet past my corner. So I only have a 2.5 foot overlap with the paving.
So how do you get a car to your house?
Yeah, maybe I wasn't very clear about that. I use an easement. I have an easement on my deed to use a shared driveway from Mountain Avenue, which is, again, just 10 feet wide. And it's literally a little less than that. And that easement is used by both my lot 17 and the lot to the north of me, which is lot 10.
And how long is that easement?
Give me a sec here.
Just give me a guess.
Well, I actually figured it out. It's about 330 feet.
Okay, thank
but
you.
It's a little tricky. It needs a drawing, but it's roughly from Mountain Avenue. If you go up Henderson to my corner, that's about 330 feet.
It's a sizable distance.
But
yes.
You don't use Henderson Avenue.
Correct.
But you front on a portion of it.
My address is 30 Henderson. I front on it. The house is built with it facing Henderson Avenue, as if someday we were going to work this out. It just hasn't happened. I did try for years.
Okay, thank you.
Karen, before we continue, there's a lot of questions being raised about access and does it make sense to continue this now before the court addresses it and the neighbors and possibly the applicant resolve this?
Well, I mean, I think what I hear the board saying is that there's concerns about impacts on the people who front on Henderson, who use Henderson because they have no other access. And what I hear the board saying is you're concerned that
I think it feels more like, I'm not even sure if this is something, as much as we might want to, I don't know if this is really our jurisdiction to rule on some of these things. That,
Well, and you have a good point, Eve.
Yep.
So right now, it's in the court's purview. The judge has sent everyone to mediation to work through easement issues. If they can't work through it, then they're coming back to the judge. And I assume then he will issue another decision.
so,
Because right now, the decision comments that, there just wasn't enough information, judge didn't have everything. So he ruled on what he felt was supported by the information presented to him. I don't know if the applicant is prepared to make any representations tonight, or my understanding is that these conditions or these concerns that are being raised by the neighbor, the applicant's view is that that should be resolved as part of the litigation. So, from the board's perspective, while I agree with Eve, these issues, given the fact that the judge is still looking at them, are not within the board's purview. It does appear it's of concern to a number of board members. So if you carry the application, it's possible that these issues will be resolved between the parties. If they aren't, then the judge will have to resolve it. He'll have to make some more rulings and figure out who can use Henderson, who can't. And if they can use Henderson, what are the terms of that? Is their obligation to help maintain the road, et cetera? So I think it boils down to, if these issues are of significant concern to the board, then continuing it is probably the only way that they will be addressed before the board, makes a decision then on the construction of the house. And I do hear, I did hear in some of the comments that Ms. Stilo made, that concerns about the driveway cutting off. We're coming extremely close to one of the properties there. I don't know if that owner is here tonight to speak to that or to any concerns they have. But in the, because the court has all these issues, it is, it's really beyond the board's purview right now to speak to them. If it weren't in litigation.
Let me ask something, Karen. Excuse me. But there are things that have been raised tonight that could affect the design of the house. And thus
Correct.
Some of the variances required.
Correct.
So it's really not appropriate for us to hear this until the court weighs in and the neighbors and the applicant get a chance to discuss it all. And then they'll have a lot conceivably, and everybody will have continued access, I assume. And all the other related issues to a private drive will be taken care of. So I don't know, we're not doing the applicant any disservice by not hearing it tonight, because they're not going to be able to start until the court has resolved all these issues.
Mr. Chair, Anthony, may I comment?
Who is this?
That's Mr. DeGrazia.
Yeah,
I know who you are.
My name is Christopher DeGrazia. I'm co-attorney on this application with Anthony Todara.
Okay, can you wait 1 second, please?
Sure. I just wanted to respond to what you said, but I'll wait.
Okay, all right, but so I'll let you speak in a moment. So my feeling is it's a little premature to hear this right now because there are a number of questions that could affect the design of the property. So that was really where I was at. I did notice that our zoning officer has her hand raised, so I'd like to hear her comment before we keep going with hearing the neighbors. Taylor, did you want to speak?
Thank you, Mr. Chairman. The only thing that I wanted to bring up was just to make sure that we're all mindful that there are 2 other applicants on for tonight and we're approaching the 10 o'clock hour. So I just wanted to be as fair as we could to everybody involved.
You're exactly right. Okay, so at this point, I think, Mr. DeGracia, you can say what please speak, and then we'll discuss this with our attorney right now. But go ahead.
Mr. Cohen, I appreciate that. Again, it's Christopher DeGrazia from the law firm of Figure, Drinker, Biddle, and Reith representing the applicant. There's been a lot of misinformation, and Mr. Chair, I do disagree with the categorization that it's not a disservice. The whole process here is trying to make a very simple application seem like it has an impact to all of these other homes and these other issues, which are property rights and title issues that are being addressed by the court. I cannot tell, there is no way that a decision by the court is going to impact the design. We are well within all of the setbacks. All of the variances are unrelated to the issues here. You have neighbors that are using this opportunity to try to delay and force the applicant here to give them whatever they want under the sun. Like you just heard from Carl Burns, who purchased a lot with legal access that he has a driveway for going up and down with his deed, and he doesn't have any rights to Henderson Avenue, and just tell you that, oh, he wants the rights there. I mean, this is not for the zoning board to grant rights. Whether he has them or not is for a court to decide. And if he does, then he does. And we have to accommodate those rights. But he has a deed with a legally granted access to that deed in the deed. He has no existing driveway. He uses the car on the other side, which somebody nicely pointed out. I mean, it's the same with the house above it. Yeah, that was purchased by the neighbor that owns the lot on Quarry Road because they wanted to have more land there. And they have a deeded access right as well, unrelated to Henderson Avenue. Or they could drive, they can add a little, stem from Quarry and get access there if they want to go through their own property. But instead, we have neighbors here arguing that, oh, it should be the owners of the lot that should grant all of these rights. It shouldn't be that way. If they have claims of title and interest, they bring it before the court and the court decides. Why it's irrelevant to this case is because it has no impact. This is not a property that's being developed from scratch. This is a property with a pre-existing house. Just like everyone else on that has access to Henderson Road has a house. Those people can live in their house. Why can't the Hendersons occupy their house? They're not changing any of the utilities. All of these statements that things are being changed, they're not. Look at the plans. Look at the actual facts, not what they're claiming. The reason why they're doing this is because they've said they want access, they want everything done, they want the Hendersons to pay for the taxes and the maintenance and all of that over and over again without doing a pro rata share. And
It's
that's
not the Hendersons. It's not
Wait,
the
they're
Hendersons.
not saying
Haters.
that yet. Wait, hold
Hendersons
on.
aren't part of this anymore.
The Hendersons aren't part of this anymore.
Oh, is that what I said? I'm sorry, I misspoke.
Okay, but the issue is all these things are being discussed by, I'll call them the stakeholders in the road and the new applicant.
Yeah, so
and so what is the negative to delaying it until that's done? Because they
Because-
can't start, they're not going to be able to start without these things being resolved.
Because we should keep the status quo, which is there's a house there and they should be able to occupy it. To make it fair, other people shouldn't be able to have access and use their house. Why do the haters have to work? I mean, litigation could take years. We don't know.
But are they going to be able to, Karen, are they going to be able to start construction? They're going to be able, even if we were to, wait a second, even if we were to grant the variances tonight, and this is all in litigation, and the roadway, the final decision on the roadway hasn't taken place yet, can they start?
I would think that as long as there's no issue with their utilities, and where they're placing the utilities, and is it impacting other people's utilities, then they very well could be able to start. I don't know, Jim, do you see any aspect of this that, from your review would prevent them from being able to begin construction?
I'm going to preface my comments with the fact that I haven't done a thorough review because the site plan has not been submitted for a zoning permit.
Right.
It has only been presented as an exhibit for the variance application. So I have yet to see stormwater management calculations.
Right.
I have yet to see utility connection details, all of those things that would normally be submitted when the permit is applied for. Right now, we're in a situation of reviewing multiple variances that the board obviously could deny one or more of them. And we're just waiting for that outcome before we get to do the thorough review of the site plans that we do for every other permit application.
But you would see a lot of this before we acted on it. You would get a chance to look at the site plans and the engineering documents. And so if there are questions related to it that we have, we would get your opinion.
Since this was a zoning a zoning variance application and not a site plan application, the board is not acting on a site plan. You're acting on variances.
Correct.
A full site plan has not been submitted to this office for review. I haven't reviewed this in detail for site plan compliance.
Okay, so if we, obviously, the drawings that were presented to us tonight are for representation, just for discussion. They're not finalized, I guess I'd say. And they wouldn't be until you've had a chance to review everything and comment on it.
Yes, the process is normally the variances get heard and approved or denied, and then an application is submitted for the zoning permit for the site development. The first process in that is an engineering site review to assure compliance with the stormwater management regulations. And at that point, all of the other requirements that would normally be looked at in zoning from a site improvement standpoint would also be reviewed. It's only after that site plan review and the land use engineer, who I am the acting land use engineer, approves the stormwater management and other elements would a zoning permit application be submitted.
Right.
So there are steps after this.
There are steps after, I agree.
Hey, Mr. DeGrazia, I think what you're hearing the board say is your client does need variances. And of course, the weighing of the variances, there's your client's claim, it's a C1 hardship, and the board weighs against it negative impacts. What you're hearing from the board is, I think they have some concerns about impacts. You've heard the chair say he's not sure if it would impact consideration of the location of the house, etc. And of course, I think the fact that we keep coming back to the court decision shows, should we say, the importance of that decision, that it's not entirely in a vacuum here. It does have impacts on your clients and the folks that are living. We have to call it a road at this point. This is where they've lived. This is where the houses have been. I'm sure that you have a lot of knowledge about this that the board doesn't have, and background and all kinds of things, but the board doesn't have that. So what you're hearing tonight is concerns from them.
And all I was saying is that none of those properties that have driveways that access are being impacted by this plan. And there's no utilities that are being impacted by the plan. You said it yourself. There's a sewer agreement. There's a PSC&G agreement. They're all staying. All those connections are staying. We're not showing any proposed changes to those. And the problem here, and from a fairness standpoint, is that we've already lost 2 years, and they are continuing to just try to put roadblocks in an effort to try to get beyond what they're entitled to. And that's really the problem here. There's a house there. They can occupy the house. They're making slight changes to the house, and the variances are really de minimis. It's width that they're not going to change, and they're mostly aesthetics based on the garage, because in a lot that width, you can't have a garage set back from the house, no matter what you do. The existing condition violates it. Any proposal is essentially going to violate it, because garages have to be at least, you got cars now that are 22 feet long, that are, the larger ones, and you need that depth. The inside of the garage is what, 25?
25, that's a big
Yeah.
difference.
Well, you'd have to have space for toys like bikes and tools and stuff like that, but 22 to 25 is not a huge difference. I mean, I have a whole set of stuff there, but all I'm saying is that ultimately the judge is going to come down and he's going to say that Carl Burns either has rights or he doesn't have rights, and it has no impact on this application. The next neighbor has rights or they don't have rights. And the applicant has shown a willingness to work with the neighbors and provide them with, assurances in these discussions and mediations. So let that process continue, but let the people that live on or near Henderson Avenue and have homes continue to live in them. And the Haydas should as well.
Mr. DeGrazia, let me ask you something. You've heard from some of the neighbors. They've asked for conditions of approval, such as their utilities won't be disturbed. They will continue. There won't be a gate. Is that something that your client is willing to agree to, or do you feel that's something that has to be addressed during your court mediation?
Well, the many of the conditions are trying to sidestep the court. I could take a look at them, but like in principle, we're not proposing any gate, and there's no gates proposed before any of the easements by necessity. So to the extent there's driveways and they have rights, we certainly can't cut those off legally, and we're not proposing any of that. In terms of, I guess I could look at the conditions, but they were really, let me try to see what they have there.
I guess wait, Karen,
Yep.
is it inappropriate for me to informally ask our board members now if they're comfortable continuing with this right now without the benefit of the court, at least getting a little further along?
Well, I mean,
Resolving.
I think that, yeah, you could just say as a consensus, you could either say, does anybody object to carrying it? Maybe that's the quickest way, or do we have a show of who would like to continue tonight? Or do you want to carry it?
All right, so board members, let's sort of go through here.
I see Michael has his hand raised.
Sure, Michael.
Normal procedure, and it's been done. You notify residents within 200 feet. They can come, they can comment. That's what we're in now. We take what they say into consideration. The attorney or the applicant can say what they like in response or what they feel is right and what they feel is incorrect. We've never limited neighbors to only talk about the impact on their house. And I found that a little bit surprising that that was put forth early. They can talk about the neighborhood and the impact on the neighborhood, and that's happened all the time. So we've heard from some neighbors. I don't know how many more we can go ahead and hear from them, in my view, and we can hear from the attorneys representing the applicant and individually make a decision. And if people read that we want them to continue, this application to be continued to a later date, then so be it. But, I'll listen to the neighbors and get that part over and see what things that may sway me one way or the other, and I'll listen to the attorneys. But if you want to do a continuance now, I'd support that.
Okay, thank you,
That's my
Michael.
long yes or no.
Well, I guess I can just ask people. Stephen, what do you think?
I believe that I cannot make a decision one way or the other on this. If it came to a vote right now, I would withhold my vote.
Eve? I'm not trying to put anybody on the spot. If you'd like to talk about this outside of this, or in closed session, I don't know how we do that.
No, we're not gonna do that. So
Okay, fine. So, Eve, what do you?
I don't know. I really hate to postpone for people but I do feel a little uneasy about just like the couple of times I've heard there are no plans to put in a gate. We have no plans for that. That is not reassuring to me, because it sounds like that's something that might, I don't know if that's considered a favor, but it just seems like to me, it's a kind of a messy situation. Haven't had experience with, where the road is owned by one and it's not really a private road in the traditional sense. I don't know how things get worked out in the long run. And
Okay.
I'm worried. I'm worried about, it may be true that the design has no impact, but I feel like having the people begin to live there may change, they may have some power. And I really hate to slow anybody down who wants to move it, make a home somewhere.
Okay. David?
Yes.
But wait, David, before you speak, George, you need to recuse yourself, remember? Didn't you say you were recusing?
Yes, I'm recusing.
Okay, well then you need to please cut your video and your audio, please. Thank you. Okay. I'm sorry. I cut off somebody.
David?
Yeah,
Oh,
no, so
sorry.
I share the concerns. That even with the best intentions, we have a situation here where this could be a toll road. they own the road and they could set any toll they wanted. It seems like without getting that resolved, it's very hard to proceed. So I would like to continue this until the situation is resolved.
Okay. All right. So, Karen, how do we do this? Should we hear from the remaining public members who are here tonight? And then, hang on, I'll let you speak, Ms. Hayda. What should we do? I mean, it's just too many questions here, and in my opinion.
Mr. Chair, since we're all here, maybe we could continue with the neighbors and hear all the testimony from the public. And then if there is some open questions, then we can talk about maybe providing some more information to the board if that's what gets the board more comfortable. Because honestly, in the end, none of these have anything to do with the application. Like I said, it's all about other properties and what their rights are, and that's what's before the court. This application has the access. It has everything. It has a house. It's really a very simple process going forward. And it's not, and Mr. Dubkin, if I'm saying that correctly, it's not a toll road. They can't charge fees for it. What we would have to do in the case of a shared asset is to determine, like, if it costs $100 for plowing for, whatever, 5 families or so, they all pay $20. It's a pro rata share is what that the court is going to have and ultimately resolve. But it has nothing to do with whether or not, this application has any impact, because there's a house there now, and the house that's being proposed has far less of an impact. They talk about fire. It's actually farther away from the other homes. So it doesn't have that 6-foot connection to the property line. It's set back 30 something feet. It has been carefully designed so that it is very much in keeping with the neighborhood. I mean, this isn't a structure that's 35 feet high, which is allowed. There's a small portion with 3 bedrooms.
I understand that, but there's the potential when you have a negotiation, and please correct me if I'm wrong, when you get everybody together to discuss this, there's the potential for the applicant to say, I'll make a change. It may not be a big change, but it may be a change. Somebody wanted the garage pushed back. The board haven't weighed in on any of these yet, any of the variances. So with all the questions, there's a potential that things may change. And so I'm just saying, what's the negative of carrying this and letting the neighbors and the applicant and the court get a little further along?
Well, it's like I said, it's because they've already been delayed a couple of years, and now it's going to be another couple of years before they can live near their daughter who has a baby.
I'm not saying, I don't know how you say it's going to be a couple of years.
Because that's how long courts take. This quiet title action has taken over a year to get to the decision of ownership. It's going to take another year. And if there's no detriment to the objectors here today, what's keeping them from delaying the process and delaying?
But Mr. DeGrazia, I think what you're hearing is that we're kind of going in a circle. The board is concerned there's detriment to the people who live on Henderson Avenue. Your position is you don't think that's the case, but in any event, that's for the court to determine. Okay, so you see we're in a catch-22. So the board says, oh, okay, we're not supposed to look at any concerns we have about detriment because the court's going to decide it. Fine. Now these neighbors have raised concerns with the board. They've said, well, could the applicants just agree they won't disturb any utilities. That's one thing they want. Could the applicant agree? They won't put a gate. They won't cut off access to Henderson Road, right? So if your clients are uncomfortable with making those representations or making those conditions because they don't feel they should have to, or because it's now within the purview of the court, then we kind of are going in a circle. So what you're hearing from the board is that they'd like to carry this. Their hope is that the parties will resolve these matters. I don't know if they will or not, but that's what you're hearing here, that you do need variances. There is a weighing of the hardship versus significant detriment, perceived detriment to other properties. So this is where we are at the moment. If your clients say, no, you really don't have to worry about that, and we're willing to represent that now, that's an option for them. But perhaps they don't want to.
Yeah, I mean, the issue there is not necessarily they don't have an objection to any existing utility that's connected. They've already said that they're not cutting off any of those utilities. I don't see that's a problem. With regard to the fence, they've said that there's no fence that's going to be put before anybody's driveways. Now, there could be at one point, sometime in the future, if they find there's a lot of people trespassing on their personal driveway where they may want to put a fence at the tip. There's nothing that's prohibiting them or any of the people that are on Henderson Avenue from doing that as well. The neighbor next door could put a little fence on their lot if they wanted to. They could. I mean, that's the kind of thing that we can't just ultimately say, we don't know what it's going to be like, because they're not going to want people coming in and using their driveway where their garage is as a
No,
turn.
it's valid that they can't block or change the right of way. I think we all understand that.
And we're not.
All right, well, look, board members, at this point, if you want to allow, because I think Taylor had indicated there were more people in the waiting room who wanted to speak from the public. If you want to continue with that, then we should let the applicants who are waiting, applications 2 and 3, if you're just going to carry them tonight, and when are they being carried to? What is the next meeting that they can be heard at?
If we carry the Green Street application and Prospect.
Yeah.
Taylor, when can we hear those two?
We have a full agenda for the scheduled August 26th meeting and the September 23rd meeting. So we're either looking for October or scheduling
special meeting.
I hate to do that, to delay them that long.
Why would we be listening to the public at this point if we're
I guess
questioning
because someone suggests, I guess one or more board members, Eve, I thought I heard someone say that's fine. If you want to hear from the public who's here tonight, we can do that. But since it's 10:15, I don't know how long that will take. So
I actually thought, pardon me, that it would be a good idea, and then it would allow us to hear all of the concerns, and then if the board adjourns this to the next meeting date, it'll give us the ability to go through and figure out a way to get to the board's comfort level. So we would appreciate hearing from the rest of the people that are here tonight, and then allowing, if we get adjourned to the next month, that gives us some time to think about what they've said and how to address the board's concerns.
I don't know if you're going to get adjourned to the next month is what I'm hearing.
Yeah, well.
Yeah.
Is the board, well, I guess you can consider a special meeting. I don't know.
The adjourning, weren't we saying that we're concerned about having it resolved in the courts before we would rule?
Yeah, see, but we have two options. When we carry something, we either carry it to a date certain, we announce the date tonight, then the applicant does not have to renotice. Or alternatively, we say, we don't know when we're gonna hear it next. We don't have a date yet. So then the applicant will have to send out notices. If
Right.
the hearing, if it can't be August, it can't be September regular meeting. If we decide we'll put it on a special meeting, the applicant, if we haven't announced that, the applicant will have to notice.
And
That's,
your attorney indicated that there may be a way to address it through conditions, and we like the opportunity to think about that for next month or whenever you can get us on, because
Okay.
we know that litigation's gonna take, way too long. So we would like the opportunity to just figure out if we can address through conditions what the board is uncomfortable with.
Mr. DeGrazia, I see your clients have their hand raised. I don't know if you're speaking for them now or you want them to speak or.
I'm not sure if they want to speak or not.
I just say, can I just clarify? There's a lot of talk about a gate. I think everybody needs to understand there will never be a gate at Mountain Avenue and the end of Henderson Avenue. Never. That would be ridiculous. And I'm on record saying that forever, in perpetuity. So the talk about a gate is ridiculous. If anything, it would be a gate just at our doorway. Sorry, I'm so beyond frustrated. This has gone on for 2 years now.
All right, well, let's first, because given the time.
Hey,
Sorry,
Karen.
Taylor, yeah.
I'm gonna bring over the attorneys for the other applicants to push
Yes.
them to the next.
Yes.
Okay.
Yep. But since it looks as if the August and September agendas are full, is the board willing to consider a special meeting? And if so,
A special meeting to hear this application or the
well,
two
to
we're
hear
not
this,
gonna
and
hear?
we've got the
What-
two others that are being carried to we don't know when.
I'm
So-
more inclined, quite frankly, to hear the other two applications, in my opinion, in a special meeting right now. Because through no fault of theirs, they're getting delayed.
Well, I mean, I'm not sure it's anybody's fault that they're being delayed, but Taylor, the applications that are on in August, are they of a nature that you think they will? It's always hard to know what will become a time-consuming application, but are they of a nature that they're more simple applications so that we could?
And I can confirm at least one is just a lot area variance. That's one that I have scheduled.
Yeah. I was gonna say one, yes. The issue is that there are 3 applications scheduled. So if commentary or, public comment gets long on one, it's gonna push another. I would think that adding another applicant to that evening would just create the same problem that we're having now.
I tend to agree with you.
I do have availability between other planning board meetings and other things, August 12th. That could be a possibility. September 2nd.
And the idea that that would be a special meeting for which applications then? For Green Street and Prospect Avenue?
Yeah.
Okay.
If I could be heard for a moment. This is Neil Yaskin. I represent the applicants at 164 Prospect. What we're looking for at the moment is we're making an assumption that we will not get heard tonight because the second application, if you hear it, sounds complicated. You also need an extension from me tonight.
Right.
I'm prepared to grant that extension, but you have to hear me ask for it and then grant it.
Well, and Mr. Yaskin, I guess if we can figure out what agenda you're being carried to, then that will facilitate the amount of extension that we need to ask from you. So,
Either of those dates, August 12th or September 2nd, that I don't know about my professionals. It works for me. As you may know, if you've seen the application, it's been greatly simplified. What
Right.
was originally a connected screened-in porch is now a simple freestanding pergola. It's the kind of thing you buy at Home Depot. We didn't even think it would be subject to FAR review, but the professionals ruled otherwise. But it's a simple application at this point.
I can appreciate what you're saying, but we're learning that nothing is simple. What about it, board members? Are you okay with a special meeting on either the 12th of August or the 2nd of September?
I'm good for the 2nd of September, but not in August.
Michael?
Likewise.
Okay.
Michael, you're muted. Michael? Okay.
I'm
Are
not
you
sure. Just a second.
okay?
Yeah, September's okay. I don't want to do it in August.
okay.
So
George, you available on September 2nd? This would be for Green Street and Prospect Avenue.
Yes.
Yeah.
Yes.
Okay. Well, then is the board amenable then, if what I'm hearing is you're willing to have a special meeting on September 2nd and 22 Green Street and 164 Prospect would be carried to that meeting date?
I'm okay with that.
Yeah.
All right, Mr. Kennedy, or your clients, can you be there? Can they be there?
I confirmed we can on the 12th. If you give me a second, I'm waiting
Okay.
for a response on the 2nd.
Okay. And Neil, you said your client can be there. You're not sure, but I guess your architect.
Nope. They just got back to me. We're all good.
We're all good. Okay.
Ready.
Yeah. I'll say we're available on the 2nd as well. Also, just say that our application, while it seems complicated, actually is quite short. So if you have 20 minutes for us tonight, we could represent. You could get to us, but understood. The 2nd is available.
All right. So actually, we now need an extension from both you, Mr. Kennedy, and you, Mr. Yoskin.
Yeah, we time out on the 31st, I believe. So
Yeah. So let's see if you both give us an extension to. Well, you want to give us an extension to September 3rd? It's cutting it close, but
I will.
it is what it is. Yep.
Yeah.
okay.
That's
All
fine.
righty. Okay.
All right. Thank you.
Then, for anybody who's interested, both the applications for 22 Green Street, 164 Prospect will be heard on September 2nd. It'll be a special meeting. We'll begin at 7:30, and the connection instructions so you can participate via Zoom will be on the website and part of the agenda.
Okay, so now I guess we'll hear from additional neighbors.
Okay. Well, then
Taylor,
let me before we
Here's
begin that, I
There's
was
a neighbor
remiss.
missing that you guys haven't let in yet. His name is
No,
Ben.
no more
What?
right now. It'll be, let the other neighbors speak, please.
Yeah, well, that's what I think they're trying to say, that there are more neighbors in the waiting room.
Oh, okay.
So we need to let them in, but I think I was remiss. I'm honestly not sure if I swore in Mr. Stilo and Mr. Brenner, so I'm going to ask you, if you both swear and affirm the testimony you gave this evening was truthful.
Absolutely, yes.
Thank you very much. Okay. So Taylor, is there anybody left?
Yeah, there's a Kathy Bogle that I am
And
Okay,
Ben.
all
promoting.
right. Where is she? Kathy Bogle. Okay.
put us on video.
Where'd you go?
Can you hear me?
Oh, there you are. Okay. We see you, sir. Can we have your name, please?
Sure, it's David Bogle,
And your address, Mr. Bogle?
148 Quarry Lane.
All right, Mr. Bogle, do you swear or affirm any testimony you give this evening will be truthful?
Yes.
Thank you.
So I'm here representing DCB LLC, which is the owner of 56 Henderson, also known as Not 10, which I noted has left off several of the applicants' exhibits.
And sir, are you a principal of that
I am.
outfit?
Yes.
Yes?
Yes.
Okay, thank you.
As I understand it, the applicants have provided the board the summary judgment, which involves the applicant and the Henderson Avenue neighbors, that is intended to satisfy the particular comment on ownership of the road. But that's far from the entire story. And I want to just point it out, it's been bannered about that we're suddenly going after the neighbors or trying to do something, this applicant. All the Henderson Avenue neighbors are the defendants. We did not bring this action. This action was brought upon us. So we are defending ourselves and not the plaintiffs. I just want everybody to understand that. So first and foremost, this judgment by the judge was only handed down July 7th, 15 days ago. So there are options that we could pursue, appeal, ask for a stay, et cetera, and do the different things. And the second, while the road ownership is addressed and granted easement of 4 of the 8 lots involved, lots 10, 17, 18, and 20 are still pending before the court. And that includes court-ordered mediation, which is still active and pending. And then third, which we haven't heard a lot about, we've heard about utilities, but the judge specifically in the order hasn't made any decisions about utilities and access to same. And so that's very important. So as the owner of 56 Henderson Avenue, also known as Lot 10, which is currently undeveloped, this is important for utilities to serve it, emergency services to get to it. It's a really big deal. And I don't see how, it's not resolved yet, clearly by the court order. And we're looking forward to resolving it, so the plaintiffs can get on with their, whatever they like to do. But I just want to point out that, much has been made about emergency access and things and, the shifting of the driveway and whether or not, their application would require changes, but they're shifting the driveway up. Several years ago, there was a very significant injury on Lot 10. And the Princeton Police, EMS, and the fire department used all of that area of Henderson Lane to access Lot 10 because there was no other way to get there. And so, that's real. So I'll be brief because I know we've been here a long time and there's other people waiting to be heard. But I urge this board to pause this application until all the legal questions are answered, not just who owns the road, but have been properly brought to conclusion so they're satisfactory on the other side. Should this board act in favor of the application, even with conditions, I think it would be premature as the current legal battle is still ongoing, and it would be tantamount to extinguishing any rights we may be entitled to, as the applicant's proposed development on Lot 11 would make any future access to utilities impossible. So, I've heard the arguments a little bit, and I'm not, in this business, but I will tell you that, to find in favor of variances, the board has to be very satisfied that there's no adverse conditions. I think you've heard from all the neighbors so far that there might indeed be adverse conditions. So you don't know how those are going to be resolved until the court has either determined one way or the other. So I urge this board to pause the application so that we can work out the issues, whether they, and move on. And that's all I have to say. Thank you very much.
You're welcome. Board members, any questions of this speaker? Okay, Taylor, can you call the next person, please?
Dan Marks.
Mr. Marks, can you unmute yourself and make yourself, we want to be able to see you and hear you. There you go. We can see you. Now
Mr.
unmute
Marks,
yourself.
are you comfortable giving us your address, please?
I am 19 Henderson Avenue.
Alrighty, sir. And do you swear or affirm any testimony you give this evening will be truthful?
I do.
Thank you.
I'll be brief. It's mostly redundant. Similar concerns about have had similar concerns that are voiced about the road remaining open, specifically for and particularly for emergency vehicles and fire trucks. There was a fire at my house in 2012, so this is real, and I think with that I can just cede any time and give us our evenings back.
Okay, thank you. Board members, any questions of this speaker? All right. Let's go to the next person. Just as a word, if there are any other speakers and you're going to speak to something that someone else has said or mentioned previously, just simply say I'm supporting so and so, or I'm agreeing with them, so we can keep moving on. Taylor, anyone else?
Yeah, there's a Ben Bayer.
Okay.
Apologies if I butchered your name.
Bayer. Okay.
Hi.
Mr. Bayer, are you comfortable giving us your address, sir?
Yes, my address is 22 Henderson Avenue.
Alrighty. And you swear or affirm any testimony you give this evening will be truthful?
Yes, I do.
Thank you.
Okay, so my lot sits sort of offset right opposite lot 11, which is 25 Henderson, which is the location for the zoning application. There are various things that I wanted to say that which I will skip over. But one thing that the legal process has done in combination with the current zoning application, it has drawn my attention to the real threat of devaluation of my own property. I plan to sell my home this spring. The outcome of the legal case has thrown my access to Henderson Avenue into a currently unresolved state of jeopardy, making my home de facto unsellable because I do not have easements from the court. This needs to be resolved, hopefully in an amicable way. So my moving plans have been upended. Now, I've had years of normal access to Henderson Avenue until now, so they need to be reestablished, and that can't be resolved here, obviously. However, when I was working with the realtor on the marketing of my home, I showed her the Hayder's plans to tear up the last paved section of Henderson Avenue and turn it into a private driveway. This is the driveway that we've been specifically talking about at various points in the meeting. Okay. Now, the realtor was very taken aback when she learned of the plans to make that driveway because of the impact it could have on my property, both practically, aesthetically, and in terms of its marketable value. And this is because the driveway, as shown in Mr. Grace's slides, which is the dark shaded area on the map, actually begins in the middle of my lot's frontage to the street. Okay, my house is oriented to the street. My lot faces right onto Henderson Avenue. Okay, so it would be almost opposite the front door of my home, would be the beginning of the private driveway, the end of the current iteration of Henderson Avenue. I've been accustomed to be able to access Henderson Avenue from any part of my frontage. The unbroken street running northward past it to two other properties makes sense, both aesthetically and practically. And a private driveway beginning halfway across my lot's frontage does not make sense in either of those terms. So I'm requesting a small revision to the planning application such that the Hayder's driveway discharges onto Henderson Avenue in its current form, i.e. in the current form of Henderson Avenue, rather than making half of my frontage inaccessible. Otherwise, half of my lot would be oriented to a completely private driveway rather than onto the street for which it was originally designed and built. So you can readily imagine that this latter scenario with the private driveway would present a rather bizarre and unappealing sight to any prospective buyer once I'm in the position of being able to sell. That's my main point. The only other point that I would like to make is that when we were in arbitration, this question of a gate was not actually to be located at the connection of Mountain Avenue and Henderson Avenue. It was to be connected at the beginning of the private driveway, i.e. the north end of Henderson Avenue. Now, Mrs. Hayder has said that there's never going to be any gate at the bottom of Henderson Avenue. I'm very concerned that there might be a gate at the beginning of the private driveway that has been proposed, which would again bisect the frontage of my property in an extremely unappealing and unaesthetic way, and totally inappropriate for the way that the neighborhood is organized. So I will stop there. Thank you very much for your consideration and for hearing my concerns.
Thank you. Thank you. Okay, board members, any question of the speaker? All right, Taylor, is there anyone else that would like to speak?
No, Mr. Chairman, I don't see anyone.
Okay, all right. So I guess to both attorneys, I guess you've heard from the neighbors, you've heard from the board. Will that give you some guidance in how you proceed?
Yeah, I think it's I think it would be beneficial for us to have a request, an adjournment to another date that's closer so that we could go through and address some of these comments. I think there's a lot of misinformation. I honestly did not think that things that were not being changed would be mischaracterized so much, but we can go through and provide information and the assurances to the board so that they can get to a level of comfort. So I think it would be it would be helpful to have that date because there was a ton of misinformation presented tonight. Just a ton of it. And we just need to be able to address it. I think if we go through and provide some more details and some exhibits and talk frankly about all of the things that the board's concerned about, we would get to a position where they'll understand. And so that's where I think we should go.
I'm fine with that. I don't want this to drag on any longer than it needs to. So, but the last speaker did raise an issue which may affect the design of the house. I'm not saying that's where it's going to go, but it does create a question as to, the location of the new house. All right.
We'll provide, we think it was a total mischaracterization of what's being proposed, Mr. Chair,
Okay.
but we'll address that. We'll show you specifically on the plans comparing to what it is today
Fine.
and what we're showing.
Okay, Taylor, when do you think we can get this application back before the board?
Do you think you'll be able to resolve the two at the September 2nd meeting and add us to that?
Oh, gosh. I mean, we could actually, in my opinion, and I'd like to hear from Karen and Taylor, we could put you on last, and if there's time, we'll hear you. We're not going to put you on first. We could put you on last.
It didn't seem like they planned on very long presentations, but you never know, right?
Right, exactly. That's what General Custer said too.
What's the other date available?
Well, one was August 20th, I think, August something, and the other was September 2nd. But we had.
Well, that's if we were scheduling another special meeting, right?
So you've
Yeah.
already got one special meeting on September 2nd. So either,
I have a third spot available on the agenda for the October 28th meeting
and
as
what
well.
about September 23rd?
So are we not
That had-
concerned with having the court settle what they, is that not in play anymore as part of, I thought that was the original reason for us postponing tonight.
Well, Eve, the
Well-
applicant is suggesting they think that if they can come back and continue their presentation, that they can alleviate concerns that the board has.
Yeah, I heard that.
I don't know if they're willing also to agree to some conditions to alleviate the neighbors' concerns. I don't know.
And there was a lot of misinformation we need to address. I mean, there was just things stated that just are factually not true. And we will like
Okay.
to have the opportunity to present that.
And that's fine. So what do you think we could, Taylor, Karen, what do you think we can do? We could, in theory, take, September 2nd and say, we'll hear the other two and I mean, obviously we can't guarantee that we'll hear this application if we have enough time after those other two,
Yeah.
or else we can, I guess, it would have to go to October. That's the next available time we have.
Yep.
Taylor, the September 23rd agenda, how many, the nature of the applications, are they more complicated or?
Three of them are scheduled. Two of them are more complicated. One of them is an interpretation. So
okay.
Is that the October date?
That's the
that's September
21st.
23rd.
Oh, 23rd. Okay.
No, that's September. Did you say October?
October 28th has two things scheduled for it, and I could schedule a third. Both of those in October are C variances, so they should be, again, famous last words, but
We would still have the special meeting on September 2nd,
yes.
specifically for Green and Prospect.
Yes.
Okay. I'm okay with August for and you would be the third on the agenda.
No, wait a minute. Taylor, were you talking about August or October?
No.
It was September 2nd for the special meeting, or
Yes.
October 28th. I have a third spot available.
Okay, so
Oh,
you're
what-
talking about carrying it to October 28th.
What did you have in August, Taylor? How many cases do we have in August?
3 in August.
Oh, we already have 3. Okay.
Yeah. One of which will be relatively easy.
Well, I
The
guess
other
we'll-
two are more complicated.
Yeah.
Well, in terms of the timing, would we be, because I'm thinking between the October and November date, I mean, the September and October date, September, we would certainly be last on the agenda. On October, would we be at the top then because of the timing? Because it's a pretty far delay. That's why I'm trying to understand in balancing the two.
Is that for me to answer?
I think so, yeah.
Unfortunately, it is.
The information
Yeah.
on them timing out, I guess.
I mean, we're pushing all of these applications out 120 days. So without pulling these files right now and getting these times, I don't know off the top of my head. But I mean, these applicants have been notified that they're scheduled for the hearing. It is up to us and the time of application to determine that. So, I mean, again, I would have to go through and look at that. I don't have those dates on the top of my head.
How many on October 28th, Taylor? You said two?
Two. Both C variances.
Okay. Okay.
And there's two on September.
I think there's three. I think in September, Taylor, is that right?
We have a special meeting September 2nd, which the
Yes.
two were carried for today. September
Yes.
23rd, there's three applications, one of which is an interpretation. But again, if we're
Okay.
scheduling fourth applications, we're getting into these same conversations.
Yeah, I agree.
So I was thinking September 2nd, because there's two. We have a better chance at that point unless we are farther up on the agenda on October. We're losing 3 months. I guess I could check in with our consultants and our client. Would you like to try this September 2nd? We would be after two other applications. Or October, and we're not sure where we would fall on the agenda. It would be October 28th.
I would think I would be comfortable with a third application on September 2nd, but that's up
I
to
think that's better as well,
client.
Mr. Chair.
Taylor, do we not have a regular September meeting scheduled?
23rd.
Do.
We do.
23rd.
Oh. Okay, yeah, we would appreciate the October 2nd. I think it looks like our team's
September
already-
2nd.
September.
I'm sorry, September 2nd. Yeah, September 2nd. I think our team's available and I think there's a pretty good shot. You know.
Okay.
Okay. Yeah.
Right, so for the benefit of those who are interested in the status of the applications being carried now to September 2nd, that meeting will be noticed as a special meeting. It will begin at 7:30. The Zoom information so that you can log on will be on the website on the agenda.
And Ms. Casey, I believe you need our consent to an extension.
We do.
Yeah, I think it times out on the 20th of August.
Yep. So
We'll do September 3rd and then we'll take it out from there.
exactly, and then we'll see where we are.
Perfect.
Thank you for the consideration.
Okay.
And I think you'll have to officially announce it for the record.
I thought I just did, but I'll do it again. This application is being carried to September 2nd. As I just said a few minutes ago, that is a special meeting. The information for participating via Zoom will be on the agenda on the town's website. The meeting will begin at 7:30, and the applicant will not be obligated to provide any further noticing.
Thank you very much. Appreciate it.
Okay, thank you, everybody. Now, board members, Karen, we
do. So what I think what we need to do is, Taylor, we need to kind of remove the our people who are not board members, get them off. Okay, so we still have Mr. Tadero. We need to cut him off. Okay. No, and Mr. DeGrazia too.
What about the,
Okay, so now we have on the
Wait a
agenda.
minute, we're still being
Hold on,
recorded.
hold on. Slow down.